Welcome to PBCJ's coverage of the sitting of the Senate. I'm Simone Absalom, and I'll provide a brief outline of what's expected to take place during the sitting. But before we begin, did you know that no more than 4 ministers can be appointed from the Senate, and they may have portfolio responsibilities? The Senate usually functions as a review chamber, considering bills passed by the House of Representatives. On the agenda in this sitting, the bill shortly entitled the Pensions Public Service Act 2016 is to be debated. The public sector pension reform is aimed at making the system more affordable and sustainable for the government while providing adequate pension benefits. Also on the agenda, the continuation of the State of the Nation debate. And that's what's on the agenda so far. It should be noted that the elements of the day's agenda can be changed or moved. But before we go, here are a few things you need to bear in mind if you plan to attend the session at Gordon House. No visitor shall create any act of disorder within the precincts of the House. No visitor shall be admitted to the House without first obtaining an admission card from the office of the clerk. Visitors who remain within the precincts of the House during a suspension of the session are asked to keep silent. No photography, videography, or sketching of the proceedings is allowed unless authorized by the presiding officer. And there should be no smoking inside the parliamentary building. Now over to the proceedings.
This Honourable Senate now resumes its sittings. Before we begin the business of the day, I bring to your attention the passing of Carlisle Dunkley, who was a member of the Senate from the 17th of March, 1972. He served as Minister of Education, I believe, Minister of National Security, and served the country in a number of capacities, including as President of the NWU. So we...
Instance, as you mentioned, former Senator and Government Minister, the Honourable Carlisle Dunkley. Mr. President and members, he was a committed public servant who served Jamaica for more than 40 years in various ministerial posts and as a former ambassador to Cuba and special envoy to CARICOM and the Association of Caribbean States. Among his other broad areas of public service was that of Senator between 1972 and 1978, Minister of Public Utilities and Transport, 1979 to 1980, then Senator again between 1980 and 1983, Lecturer of the University of the West Indies between 1982 and 1989, Spokesman on Education between 1984 and 1989, and then Minister of Education 1989 to 1991, and Minister of Production, Mining and Commerce thereafter. Although well accustomed to the rough and tumble of fierce trade union negotiations and what we call sometimes rivalry, his was a generally amicable and congenial personality. He could have passionate debates in defense of his perspective without any sense of malice or ill will. Mr. President, Mr. Dunkley's commitment to Jamaica, and indeed the wider Caribbean, was also reflected in his passionate advocacy for regionalism and for the interests of the broad cross-section of the Jamaican society. We on this side would like to make special mention of his years of service to the education sector, in which he sought to articulate the needs of those who had less access to education. I therefore, on behalf of my colleagues and indeed the people of Jamaica, wish to extend our condolences to his family and colleagues in the trade union movement and the political movement. May his soul rest in peace.
Mr. President.
Thank you, Senator Reid. Senator Brown.
Thank you very much, sir. I join with Senator Reid, who himself would love to be labeled as a trade unionist. In this sad moment, as we pay tribute to the Honourable Carlisle Dunkley Order of Jamaica. In the short time that I've sat in the Senate, I want to pay tribute to other trade unionists who have served there. And I'm sorry my friend, Senator Gale, is not here today, because I'm sure he would join me in the tribute I pay to the Honourable Carlisle Dunkley. Clive Dobson, Upton Cavan, Lloyd Goodley, recently McPherson. They must be welcoming in that great pantheon in the sky the arrival of Carlisle. Lincus, as some of us call him, suffered from, in this chamber, as Deputy President of the Senate between 72 and 78. He brought his enormous trade union experience to bear upon the deliberations in this chamber. He left this chamber and went in the other place in 1978 in a by-election replacing Dr. Ken McNeil. He didn't survive the swing in 1980, and he came back to the Senate. He was fiercely loyal to Michael Manley. Mr. President, Carlisle had a dry wit about him. During the 1978 debate, 75 debate on the Labor Relations and Industrial Dispute Act, he rose in defense of the bill, speaking after an opposition senator, I think it was Senator Leon Osang. And Carlisle calmly dispatched the passionate presentation of Senator Osang in the following terms. Thank you, Mr. President. I will not attempt to pursue all the balls that were bowled outside the half stump by the previous senator. I will deal with some of the points he raised. Regrettably, not all of them were clothed in validity. That was the dry wit of the man who had dedicated many of his years working with the National Workers' Union, rising to the position of island supervisor and ultimately president of that venerable trade union. The members of the National Workers' Union, in particular those in bauxite, in sugar, in manufacturing, benefited extensively from his effective negotiation skills and his willingness to share his great intellect with all. He focused a lot on worker education. His dedication to the cause of the workers can be seen in his seminal contribution in this chamber to the LRI debate, the Labor Relations and Industrial Dispute Act debate, one that many current parliamentarians would do well to read and to emulate in light of some of the discussions I'm hearing recently. In that speech, Mr. President, he said, in part, the trade union movement welcomes a number of features of the law. There are areas in which we have reservations, but the particular features that we welcome are the recognition of trade unions and also the areas of reinstatement of wrongfully dismissed worker. The employer class in Jamaica has ruled the roost from a number of years in which they have been able to determine things as they see fit. And this law will hasten a number of important changes in the industrial relations field. This government, sir, he said, has the honor of having repealed the Master and Servant Act. The very name, Carlyle Dunkley said, is offensive. The very name is suggestive of a mentality that is certainly way before the 20th century. And he said much more. Senator Reid has outlined a number of ministries that he served in. And it's not many Jamaicans have got the chance of being a minister of government, much less to serve in so many different portfolios. And for that, we give him thanks. His ambassadorial services have been recognized. And on a personal level, I recall many discussions with Carlyle. One of the last discussions we had was while he was Minister of Commerce. There was a decision of the Industrial Dispute Tribunal which attracted a lot of national comment. We met at a gas station in passing in Ligony, and we had a long discussion. He putting forward the view as Minister of Commerce as to what he thought the employer's position was. I explained to him the worker's position, and I'm happy to say, arising from that conversation, some positive change took place through the cabinet in respect to the Industrial Dispute Tribunal. I close by saying, Mr. President, that a grateful working class and trade union movement wishes to thank the family of the Honourable Carlyle Dunkley for allowing him to have served the movement and the people with the distinction he did. I personally thank this giant of the trade union movement for his outstanding service in so many capacities to the nation he loved so much. Some of us, and all of us on this side, will say, Mr. President, he heard the trumpet and he answered the call. He was determined that Jamaica would become a nobler place and that would become a loftier race. May his soul rest in peace and light perpetually shine upon him. To his family, again we say thank you. May it please you, Mr. President.
In recognition of the Honourable Carlyle Dunkley's service to the country, and in particular to this Senate, I would ask the members to rise and be silent for 1 minute. Just to bring to the attention of the members too, I'm informed that the state funeral for Lady Cook will be at the East Queen Street Baptist Church on Friday the 30th, that's next week Friday, at 10 a.m. Statements by ministers. Announcements.
Laid on the table of the Senate today are the following: annual report on audited financial statements of the Overseas Examinations Commission for the year 2015-2016, annual report on audited financial statements of the Early Childhood Commission for the year 2015-2016, annual report on audited financial statements of the National Road Operating and Constructing Company Limited, NROC, for the financial year 2015-2016, annual report on audited financial statements of the Rural Electrification Program Limited for the financial year 2012-2013, and the Judicial Salaries Order 2017 under the Judiciary Act. Thank you.
Bills brought from the Honourable House of Representatives.
The following is a message from the Speaker of the House. To the Honourable Senate, I have the honour to advise the Honourable Senate that on the 13th day of June 2017, a bill entitled An Act to Repeal the Agricultural Credit Board Act to make new provisions relating to agricultural credit arrangements by transferring certain functions currently with the Agricultural Credit Board to the Registrar of Cooperative Societies to establish the Agricultural Appeal Tribunal and for connected matters was passed in the House of Representatives with 18 amendments. Signed, Pernell P. Charles, CD, JP, MP, Speaker of the House of Representatives.
Mr. President, I wish to signify on behalf of the Leader of Government Business my willingness to take charge of this bill.
Thank you, Senator Reid.
A bill shortly entitled the Agricultural Loan Societies and Approved Organizations Act 2017 read the first time.
Mr. President, I beg to give notice of second reading of the bill.
Petitions, papers, reports from committees, notices of motions given orally, questions and answers to questions, motions that may be made at the commencement of public business requiring notice, motions relating to the sitting of the Senate, motions for leave to introduce bills, the presentation of bills without the leave of the Senate first obtained, public business.
Mr. President, we intend to commence the debate on the Public Service, the Pensions Public Service Act of 2017. We do not intend to close this debate today, Mr. President. We perhaps would seek to have a presentation on the state of the nation. I don't know if, right. So we will proceed in that order, Mr. President.
Senator Reid, there is a related constitutional.
Yes, so we're
going to take the both of them at the same time.
We will take both of them at the same time, Mr. President. The constitutional and the Pensions Act.
Proceed, please. Thank you.
Thank you. Mr. President and members, Jamaica is fortunate, Mr. President, to have a very good record of not only trade unionism and support for our workers, but equally, as much as we've had problems with our health sector from time to time, the truth is that Jamaicans actually are living much longer. And the issue of pension, no doubt, is one that we're all concerned about. So as persons continue to live longer, Mr. President, it's important that steps are taken to save for one's pension. It is often said that persons should begin saving for their pension the first day they start working, and it probably is a campaign that we'll have to undertake. So few persons outside of government actually are in a pension plan. No longer can persons depend on their children as old age patients from a culture where people are having 15, 16 children. The birth rate is drastically falling anyway. And as such, individuals should play, in our view, an active role in retirement planning while it's in the labor force. Over the years, the cost of public sector pensions has been increasing and will likely to continue as pensioners, as I mentioned earlier, in fact, are living longer and expect to even live longer. I think we now have a record of having the oldest living human being in the world. In 2010, Mr. President, the pension expenditure was approximately $17 billion. That's what government has to pay out. And currently the pension expenditure for this current fiscal year is projected to be over $30 billion. And it is likely, in fact, I would say it is certain, to continue to increase at this rate. The current public sector pension arrangement, therefore, is unsustainable, as only a small portion of the public sector workers, in fact, make contributions. These contributions are not related to their pension benefit. The government has a defined benefit program. Consequently, this has serious implications for an already high debt to GDP ratio. Overall, public debt is unsustainably high. Public sector pension reform, therefore, is aimed at making the system more affordable and, importantly, sustainable for the government while providing adequate pension benefits. It should be recalled, Mr. President and members, that a collective green paper on options to reform of the public sector pension was tabled in Parliament, in fact, some time ago in 2011. And this was after consultations and presentations by different stakeholder groups at the Joint Select Committee, and recommendations were made. Subsequently, the white paper on public sector pension reform was developed and tabled in Parliament in December of 2013. While the reform, as outlined in the bill, will not completely eliminate the cost to the government, it serves, Mr. President, and in fact, it will reduce this burden. It should be noted that the intention of the reform is not a panacea, but the intention is to review the reform system after a specified period with the aim to determine if and when other reforms are required, as noted in Clause 38 of the bill. The reform of the public sector pension arrangement is critical, as one of the objectives of the reform is to address the increasing burden that pensions have on the government's budget. It should be noted that when the Caribbean Actuarial Association, CAA, had conducted actuarial analysis of the period 2011-12, they had advised that the legacy liability to the government was some 222.6 billion Jamaican dollars, or 18% of GDP at the end of 2011. The legacy liability is the amount that is accruing for current workers and pensioners, which the government would be liable to pay. The CAA had recommended that the government contribute, in fact, 3.5% plus $17 billion per annum over 40 years to fund the legacy cost. It should be noted that this was based on their recommendation for reform, which included contributions of 5% by employees, reduction factor 5% for early retirement, an accrual rate of 2% for service pre-reform and post-reform. No restoration, salary used in computation, the average of the last 5 years, immediate increase in retirement age to a mandatory 65 years. Another actuarial analysis would have to be done to update the figures, but it is a fair assumption that the legacy liabilities would have increased since then. So, Mr. President, this bill therefore seeks to give effect to the policy proposals contained in the said white paper. As you may recall, the bill was tabled in Parliament in July 2016. However, subsequent to the tabling, the government listened to the concerns raised by the trade union movement and has met with them and with different groups in the sector in order to settle some of the issues relating to public sector pension reform. This is a listening government. Consequent to those meetings, there were 38 amendments. This is part of the action, Mr. President. Having listened, we're acting. There were 38 amendments that were moved and approved when the bill was debated in the House of Representatives. It should be noted, however, that while some amendments were proposed, there have been additional amendments based on further consultation, more action. The amendments have included deleting the reference to the implementation date of April 1, 2016 and a reference to March 31, 2016 and replacing it with a date to be prescribed by order. B, phasing in the contribution rate of 5%, which seeks to recognize the hardship which would have been placed on the backs of some groups, like the police and the teachers, if the contribution were raised back to 5% in a one-off situation. Amendment including removing the penalty for early retirement and inserting a sunset clause for the early retirement program which the government has now embarked on. So, President, the Senate should note that there are a few amendments which have been moved to bring further clarification to the bill. The amendments include an amendment to Clause 33A to clarify who qualifies as a contractual employee. The paragraph is being amended to read contractual employees, whether employed under a fixed-term basis or otherwise. B, at Clause 11.1, an amendment is being proposed to indicate the contributions which are to be deducted should be paid into the fund. This will ensure that it is consistent with Clause 10.1 and also clearly indicate where the contributions are to be paid. And further, at Clause 11.2, there was an omission to the amendment passed in the House of Representatives. As such, this clause is being amended to delete the reference of 5% of such salary and replace it with as may be prescribed by the minister by order published in the Gazette, which is consistent with the other amendments which were approved by the House. C, Clause 28.4 is proposed to be deleted because the benefits to what we call a deceased pensionable officer's beneficiaries should not be reduced simply because they are getting a benefit under any other enactment, especially since now all will be required to contribute. D, Clause 30 deals with survivor benefits. In the definition of the term relevant child in this clause, there is an important omission. While it speaks to the child of both spouses, or a child of one spouse who is accepted by the other spouse, it fails to speak about the child of the pensionable officer. As such, an amendment has been moved to include a Part C, to include a child of a pensionable officer. Clause 33, Mr. President, deals with the notification of names of beneficiaries by the pensionable officer, but it does not give the pensionable officer the opportunity to make any corrections or amendments to the list. Therefore, an amendment is being moved in this clause to give the officer the express permission to modify the information required by this clause. It is important, Mr. President, that guidelines are given to the Board of Trustees when they are making any decision, and as such, an amendment is being moved to Clause 37 to stipulate that the minister can make regulations giving guidelines to the board when it has to issue directions. Such guidelines could include the directions that the board issues relating to the use of any surplus. So, Mr. President, having dealt with those proposed amendments, I now quickly move through the rest of the clauses. Mr. President, Clause 5 provides for the payment of pension, gratuity, and allowance out of the consolidated fund and out of a segregated fund once it is established. Clause 5 also includes a provision that if the segregated fund is unable to meet its liabilities, then the payment will be made from the consolidated fund. So I want it to be very clear that there is a misinformation that the government is not going to be contributing because the fund as is being contemplated. Even where there's a shortfall, the government is going to make up the shortfall. So there must be no misunderstanding that this is about only the workers making contribution. It should be also noted that an amendment was moved and approved in the House to subsection 4 of this section to be consistent with the provisions of the second schedule, which stipulates that it is the Board of Trustees that has the fiduciary responsibility for the fund. So the amendment is for the board to determine the use of any actuarial surplus subsequent to the advice of an actuary. A further amendment was also made to subsection 4 of Clause 7 to indicate that the segregated fund would be established once the debt to GDP ratio reaches 60%, which is consistent with the fiscal targets. And I think it's also important we bear these in mind because we still have signed an IMF agreement and these targets are important. Mr. President, Clause 8 provides for the establishment of a Board of Trustees. The board will have overall fiduciary responsibility for the fund's management and control. This section also contains provisions referring to the second schedule, which gives details about the constitution of the board and also contains provisions relating to the function, management, and control of the fund. It should be noted that the members who will constitute the board will include representatives from the major trade unions and an actuary. The board, Mr. President, will include representatives from the major trade unions and an actuary. The second schedule also outlines the functions and management and control of the fund, including investment guidelines. Clause 10 and 11 outline the employee's contribution and also GOJ's contribution as an employer. The bill tabled in July of 2016 has the employee's contributions as 5% of salary. However, please note that the amendments were moved in the House to have the contribution rate to be prescribed, recognizing the concerns of the stakeholders and the agreement to phase in contribution rate over a period of 3 years. It is important to note, Mr. President, that Clause 12 contains provisions describing circumstances when employees are entitled for a refund of contribution. Circumstances including the resignation of a pensionable officer with less than 10 years of service and on the abolition of office of an officer with less than 10 years of service. It should be noted that this provision is also included to ensure that where a post is abolished, a pensionable officer is entitled to a redundancy payment in accordance with the Employment Termination and Redundancy Payments Act, similar to what exists in the private sector. Clause 14 and 15 contains provisions relating to early retirement and normal retirement. These sections are not applicable. Note, these sections are not applicable to the police. I'll deal with that in a little while. The normal retirement age being proposed, Mr. President, for officers of government will be 65, and for early retirement age will be 5 years prior to the normal retirement age, which will be 60. Notwithstanding, during the 5-year transition period beginning on a period to be prescribed by the minister by order for existing officers before the reform, the normal and early retirement ages will gradually increase to 65 and 60 years respectively. An amendment, Mr. President, was moved and approved in the House to remove the penalty of 1% for each year of early retirement prior to the normal retirement age from his pension, noting the concerns of the workers and their unions. Clause 23 of the bill contains a special provision relating to payment of pensions and early retirement for constables. Recognizing the unique nature of the work of our police, an amendment was moved and approved to Section 23 of the bill to allow the police to retire, Mr. President, at 50 years old after completing no less than 30 years of service, subject to the approval of the Governor General. Part 9 of the bill contains provision relating to survivors' benefit. As such, the clauses in this part stipulate the circumstances under which beneficiaries of deceased employees would get a benefit. It is important to note that survivors' benefit would now be applicable to current public sector workers who didn't enjoy such a benefit. Let me repeat, in this bill, in this provision, Mr. President, we are saying that is a major improvement for the workers because many, certainly the teachers, for example, didn't have this benefit before. So this is a benefit of great import that the survivors importantly, President, recognizing the pension reform is an ongoing process. Ongoing process, not an event. Clause 38 contains provision for the periodic review of the legislation. First review will be conducted no later than 2 years after the commencement of the Act. Clause 42 is a transitional provision which seeks to ensure that persons continue to receive benefits under the repeal acts. This section also contains provisions to ensure that the service of all existing officers prior to the reform date is taken into account for award of pension, gratuity, or other allowances. The new subpart B of Part 12, Special Early Retirement Program, Clause 44 to 50, was moved and approved in the House, includes provisions to accommodate a special early retirement program which the government will offer to applicable employees for a specific time period between April 1, 2017 and April 30th, 2018. Under this program, Mr. President, the participants will retire under the applicable current pension enactments which are being repealed in this bill. As such, this amendment seeks to exempt participants of the program from the provision of this bill. The second schedule, Mr. President, outlined the provisions relating to the constitution and operation of the Board of Trustees. It also contains provision for management and management, and investment of funds. The third schedule contains the consequential amendments to the various pieces of legislation. Note that the amendments which were moved in this section are consistent with the other amendments moved in Clause 11 to prescribe by order the contribution to be made by employees under the relevant enactment. Mr. President, I will now seek to speak to the matter of the Constitution Amendment Bill. This bill contains important amendments to Section 133 and 134 of the Constitution to ensure that once the segregated fund is established, payment of pensions can continue. So therefore, in conclusion, Mr. President, this bill, let it be very clear, this bill and this government is pro-worker. The government, Mr. President, is duty-bound, Senator Brown, to respond to the concerns of especially public sector employees, and having heard their appeal for help, has taken the necessary steps to address their concerns. And we appreciate their hard work and their sacrifice. In this way, Mr. President, we are helping to protect the interests of the hard-working public servants of Jamaica. Mr. President, let us be very clear. The longer the reform process is delayed, the greater the liabilities that the government will accrue, and the worse off it will eventually be for the new pensioners if the government cannot finance payment of pensions. Mr. President, I close. This is the beginning of the reform process, and this government remains committed to further dialogue as we seek to improve the benefits to the workers of the public sector of Jamaica. Thank you very much, Mr. President, and invite all the members to continue.
Thank you, Senator Reid. Senator Golden. Now, you might have noticed I demonstrated a bit of lenience with Senator Brown with his sort of water remarks and not putting up with it from this side.
I hadn't noticed, Mr. President. I hadn't noticed. Thank you. Thank you, Mr. President. Mr. President, the situation in relation to pensions in the public sector is the single most challenging financial matter Jamaica faces. The situation is fairly alarming, as has been indicated by the presentation made by Minister Reid. If one looks at the growth in the volume and the amount of annual pension payments that are charged on the consolidated fund of the country, one sees that, as has been stated, the annual figure of 17 billion in 2010 has grown this fiscal year to over 30 billion. And if you don't just look on a cash basis as to what's paid each year currently, but if you look at what the future liabilities are based on the employment profile within the public sector. In 2011, the Caribbean Association of Actuaries valued the total pension liabilities, which they call the legacy liabilities, which are accruing and will become payable in the future, at over $220 billion, which is, at that time, was 18% or so of the national GDP. And it's important to note that we don't factor these future liabilities in our public debt calculations, in our debt to GDP ratio. These are not part of the indebtedness that makes up the debt to GDP ratio as for the purposes of the Financial Administration and Accounting Act and the fiscal targets that we have. It's a very serious situation facing the country, and there's really nothing to crow about in this legislation because it represents an attempt by the government, and indeed the previous government, because this bill was tabled in its original form under our watch. It's an attempt by the government of Jamaica to deal with this very serious and difficult situation. It's calculated by reference to a formula. And that formula does not have any link with the amount of money that the employee contributed to the scheme over his or her life up to the point of retirement. So therefore, it frequently arises in a defined benefit scheme that the liabilities of the scheme are not fully matched by the resources of the scheme. And that may be in the form of a surplus in good times, or if the number of employees falls dramatically or other such factors, or it may result in a deficit if the performance of the underlying investments isn't what one would have hoped, or if the volume of the number of employees is maintained or grows, or other factors. And in the case of a defined benefit scheme in the private sector, the risk of that deficit is borne by the company, the employer company. And under international financial reporting standards, that now has to be recognized as a liability in the financial statements of the company. As a result of this, the trend in recent years has been to move away from defined benefit pension plans because of the fact that the employee receives a benefit which is not financially linked to his or her contributions, and that the risk of insufficiency is borne by the firm, the company, and therefore, in a sense, not only by the shareholders, but by future employees of the company who bear the risk of the company being unable to survive as a result of the potential liability that it may face if there's a deficit. And most companies have moved, who maintain pension schemes, have moved to the other main form of pension fund, which is a defined contribution scheme. A defined contribution scheme is one in which the benefit payable on retirement is not fixed by reference to a formula of any kind, but is directly relates to what is in the employee's account in the fund as at the date of his retirement or her retirement. And that, of course, it depends on the contributions that have been made by the employee, and indeed matching contributions made by the employer. Therefore, in a defined contribution plan, there's much less risk of insolvency of the sponsoring company being impacted by deficits in the plan, because in the normal course of things, the way in which the plan is designed avoids the possibility of a deficit, given that the benefits are dependent on the funding and are linked to the funding that has been put in by way of contributions by participants in the plan. Jamaica has taken the decision, and this was recommended by the actuaries, the Caribbean Association of Actuaries, has taken decision to go with a defined benefit plan for our public sector. It means that the risk of underfunding will be borne by the taxpayers of the country going forward, and not by the public sector workers. This is an important decision that has been taken, and in fairness, it was taken some time ago. But it's a decision which is controversial in the sense that it is not in keeping with the current trends in the wider economy for how risks should be shared in relation to pensions. And we will see in the years to come the extent to which that decision impacts taxpayers in the future. I have a number of points on the bill, but I don't want to make an inordinately lengthy presentation. So what I propose to do, Minister, if you will oblige me, and Mr. President, is to just focus on what I would regard as some of the bigger issues. But in the committee stage, there are a number of other issues which are of importance, which I would want to raise. Normally one is supposed to foreshadow those issues before in one's contribution, and I may have to do that, though I hope it doesn't mean that I speak for too long. I thought that would attract your concurrence, Mr. President. I think the starting point should really be the bill that amends the Constitution. The arrangements in relation to the payment of pensions are governed by a series of statutes, which are being, many of them, if not all, are being repealed by this bill. But they are, the source of the arrangements is the Constitution. And Section 133 of the Constitution in particular, which currently reads, awards granted under any law for the time being in force in Jamaica in respect to the public service shall be charged on and paid out of the consolidated fund. This is an important provision because the effect of it is to ensure that the pension liabilities of the government to retiring employees have to be paid, and have to be paid out of the consolidated fund. And this is not a non-discretionary expenditure. That is being amended, and it's an important amendment, by making that provision subject to subsection 2, a new subsection 2. And subsection 2 says that that provision, which provides for the awards being charged on and paid out of the consolidated fund, not to apply to pensions, etc., that are payable out of a pension fund pursuant to a contributory pension scheme established by law for the time being in force in Jamaica in respect to the public service. But there's a very important proviso to subsection 2, because it says, however, where the pension fund is at any time unable to pay any sum by way of pension, etc., which the pension fund is required to pay under such law, that sum shall, and these are the magic words, to the extent that such law so provides, be charged on and paid out of the consolidated fund. The effect of this amendment, Mr. President, is that whereas currently the Constitution requires sums payable by way of pension to be paid out of the consolidated fund, and indeed charges those liabilities to the consolidated fund, the amendment says that that arises and that is maintained to the extent that the law which provides for the pension fund's establishment so requires or so provides. And this is an important difference between what has existed up to now and what will exist going forward, because it means that Parliament can, as the controller of legislation, without amending the Constitution further, eliminate the consolidated fund's liability to pay pensions if this pension fund is insufficient. And I'm not saying that's wrong or right. We are in difficult waters here because we're dealing with huge sums of money, which have, and the state's capacity to maintain its own solvency. We must not play politics with this one. But I'm pointing it out to the Parliament because I'm not sure it has been fully understood by parliamentarians. The other provision in the bill which amends the Constitution, which is, I should have mentioned, it's called the Constitution Amendment Established Fund Payment of Pensions Act 2017 is Clause 3. And Clause 3 is dealing with the situation that exists now in relation to the Governor General's role. And that is found in section 134 of the Constitution. And I'm talking about the Governor General's role in relation to pensions. Because it says that currently, 134 says the power to grant any award under any pensions law is hereby vested in the Governor General. In short, I've truncated it to get to the essence of the provision. And we have made that subject to subsection 4, a new subsection 4, which says that that provision shall no longer apply where a contributory pension scheme is established by law. And as from the date that a pension fund is established under that law, pensions, etc., shall be paid out of the pension fund in accordance with the contributory pension scheme, and therefore are no longer at the behest of the Governor General, which is what had previously applied. So I just went into the constitutional amendment because I think, especially the first point, is a very important point to understand. I move to the main bill. When I say the main bill, the bill that is establishing a new regime for pensions in the public service, and it's called the Pensions Public Service Act 2017. And I move, first of all, to Clause 5 of the bill. And Clause 5 is a very, very important clause. It says, subject to Section 42.1, and 42.1 is important because what 42.1 does is basically, as I understand it, preserve the situation in which all existing pensioners who are receiving pensions from the government as at a date which is to be determined by the minister by order, and I have a comment on that, but as at whatever that date is, anybody who is receiving a pension at that time who was formerly a public sector worker will continue to receive their pensions in the same manner as they do now, or as they do as at that date, so that they're not going to be paid out of the fund. Their pensions are payable out of the consolidated fund directly and have no relationship with the fund. That is what I think the word subject to Section 42.1 achieve, and that is what Section 42.1 seeks to achieve. But subject to that, as regards persons who will be retiring from the public service after that date, Section 5 is a critical provision, and it says, until the fund is established, because the scheme comes into effect before the fund is established. That's the way it appears to be. Until the fund is established, the pensions payable to persons who are retiring are charged and paid out of the consolidated fund. But once the fund is established, then the pensions are to be paid out of the fund itself. So the fund becomes the legal mechanism through which payments of pensions are to be made for all persons retiring from the public service after this date. And this date is a date that the minister will determine. Subsection 2 is important as well, and in fact critical, because it says, if the fund, when established, is at any time unable to pay any sum by way of pension, etc., which the fund is required to pay under this Act, such sum shall be charged on and paid out of the consolidated fund. So what this means is that if there's a shortfall in the pension fund, and there will be a shortfall in the pension fund, I expect, for many years, because the contributions are going to be made only from a date which was supposed to have been April 1 this year, but the can has been kicked down the road again, so the contributions aren't yet starting, but the contributions are going to start at some future time. It is not clear that the employer's contributions are going to be start at the same time, and indeed the quantum of the employer contributions is unknown. And indeed, the quantum of the employee contributions is unknown, because under the Memorandum of Objects and Reasons in the bill, it said that they were going to employees would contribute 5% of salary. That's what the Minister Shaw said in his Memorandum of Objects and Reasons. But that has been changed in the bill, I think in an amendment made in the House, I want to understand from the Minister. And so that is unknown and will be determined by the Minister by order at a future date, as will the size of the employer contributions. So the liabilities that the fund will have, based on the expected volume of retirement and so on, one would think will far outstretch the contributions which are just starting to be made, and there will be a shortfall on an ongoing basis, and that will have to be met out of the consolidated fund. But what is important in this regard is that the provision that requires that shortfall to be met out of the consolidated fund is now in an Act of Parliament and not in the Constitution of Jamaica. And that's fundamental from the point of view of the security of the overall arrangement, because, as we know, an Act of Parliament can be passed by a simple majority of both houses, whereas the Constitution has other features in terms of how bills are passed. And even if it's not an entrenched provision, and I'm not sure whether 133 is or is not, but that can be checked easily, it's still, the procedure for amending it is a little different to a normal bill. So that's an important difference. The third point I wish to make on the bill is to do with membership of the scheme. The bill doesn't define in the definition provision who a member is. In clause 6, it says that all pensionable officers, with effect from a date to be determined by the minister, all dates in this bill are unknown, and all contributions are unknown. The meat and potatoes is at the behest of the minister and will be revealed, no doubt, at a future time. But all pensionable officers as at that date shall become members of the scheme and shall be required to contribute to the scheme upon its establishment, contribute to the fund upon its establishment under 7.4. What is not clear whether those are the only persons who are members or are persons who are formally members as pensionable officers but retire and become pensioners paid out of the fund. Are they members or not? And I think it would be useful to have that clarified for other reasons in the bill. The next point I want to make relates to the funding of the fund. And just a point to say that if you look at clause 7 and subsection 2 of the bill, it says there shall be paid into the fund. And A says all contributions made by pensionable officers as members. And B says all contributions made by the government of Jamaica to the fund as employer. So this is an important provision, and it establishes the fact that the fund is segregated. It's one of the provisions that establishes that the fund is segregated. Clause 9 of the bill makes that clear as well. And this is another way in which the establishment of this fund is going to create challenges for the government. Because currently, where employees make contributions to their pensions, and some do, as has been said, depending on the category of worker, the level of contribution differs, and some don't make any. But many do make a contribution. But those contributions are retained by the government and form part of its own cash flow. Once this is set up, that will cease to apply. Contributions will have to be paid out of their salaries into the fund, which is not part of the cash resources of the government. And similarly, so the government loses the benefit of being able to use that cash in its ordinary operations on a daily basis. Furthermore, the government is going to have to, at some point, though this doesn't say when, make its own contributions as employer to the fund. And those, of course, will also be an expense on the annual budget. So what we see is funding being taken out of the resources of the government and put into the fund to support the pension liabilities going forward. And this is important as a difference between what prevails now. But subsection 4 is a critical provision as well, 7.4. And this has changed somewhat from when the bill was tabled originally. When it was originally tabled, the date that the government would start making contributions was a date to be determined by the minister by order. And that still remains, but it is now conditioned on certain things. First of all, it is conditioned on the minister being satisfied that the debt to GDP ratio has reached 60% after consultation with the Auditor General. Now, under the fiscal rules and the overall framework for our fiscal affairs in the Financial Administration Audit Act, the target is to reach our debt to GDP ratio to reach 60% by the fiscal year 2025-26. So that is some 8 or so years away. We don't know whether or not that will be achieved, but that date is based on the projected targets under the IMF program and the economic modeling, financial modeling that has taken place to see the trajectory with which the government debt is coming down, and it has been coming down. But for this year, I believe, partly due to a change of accounting for how the public debt is calculated, where holdings of debt within the public sector are now excluded from cross-holdings, are excluded except where, as regards holdings of the Bank of Jamaica. So that reduced the debt to GDP ratio just by an accounting exercise, I think by 9% at the beginning of this fiscal year. And so I think the target is to take the public debt down to 7% of GDP by the end of the current fiscal year. Now, we don't know when the debt to GDP ratio will reach 60%. There's a commitment in the Financial Administration and Audit Act to try and achieve that by the year 2025-26, but that may or may not be achieved. But what this is now saying is that it's not until it is in fact achieved that the government as employer will start making employers' contributions to this pension fund. That is so in other words, the employers' contributions are being deferred for a period of over some 8 years based on current projections, but we don't know. It could be sooner, it could be later. And in the meantime, the employees will be expected to make their contributions. I'm not sure to what extent that could be regarded as an employee-friendly provision. Secondly, the provision 7.4 also says that the minister must be satisfied that the establishment and operation of the fund will not result in non-compliance with any of the requirements specified in Section 48C of the Financial Administration and Audit Act, which are the fiscal targets. Now, those include the primary surplus target, I believe, and the target for the public sector wage bill relative to GDP. I'm not sure if that's in 48C. But what this is saying is that if the payment out of the budget into the fund of employer contributions would mean that we can't make our primary surplus target, even if our debt to GDP ratio is at 60%, then the employer contributions are not to be made. So we have the government's commitment to the making of contributions to the pension fund subject to those two somewhat imponderable or unknown factors. The debt to GDP ratio having been reduced substantially from where it is now to 60%, and that the operation of the fund and its establishment will not have the effect of putting the government out of compliance with any of its fiscal targets. So that is a significant change to what had existed when the bill was brought to Parliament. And the provision, subsection 4, goes on to say, pending the establishment of the fund, the contributions, all of the contributions, are to be paid into the consolidated fund. So the employee contributions are not segregated, but remain in the government's cash flow as they now are, and clearly the employer contributions really don't arise because those don't start until these factors have been met. One thing that is not clear to me is whether prior to the establishment of the fund, the scheme set up by Clause 6 is treated as being in effect or not. In a sense, it's window dressing because the contributions stay in the consolidated fund, and therefore nothing really changes relative to what now applies, because the employee contributions stay in the fund and the employer contributions are not being made until the fund is established. But nevertheless, it does appear that the scheme is in effect in that initial period, notwithstanding that the fund hasn't been set up. And I suppose that means that the contributions can be changed. The size of the contributions of employees can be changed from what they are now under the statutes that are being repealed to whatever is the level that is going to be set by the minister. Again, unknown in this bill, though the Memorandum of Objects and Reasons indicated it would be 5% of the employees' pay. We don't know if it will be 5 or what it will be, but presumably the contributions can be fixed by the minister by order under the scheme, even though the cash coming out of the employee's salary stays in the consolidated fund for the government to spend. I move to Clause 9, important provision, although the marginal note doesn't really make it clear. But essentially, it says that the property of the fund and the money in the fund is held in trust for the members of the scheme. Again, that is why I think it's important to know who the members are. Who are the beneficiaries of the trust being created by Clause 9? Clearly, the pensionable officers who are making contributions are members, but are persons receiving the benefits who were formerly employed as pensional officers, are they also treated as members or not? Because the trust is for the members. And I think that's important and should be clarified. What is another point to be made? Clause 10, Mr. President. Clause 10 bifurcates or separates the payment of the employer contributions in terms of timing, the commencement of that, from the establishment of the fund. And we've already seen that the date of the establishment of the fund is an unknown date and is dependent on some very serious things having been achieved. But Clause 10 of the bill says that commencing as from such date as a minister shall determine, the government shall pay into the fund, etc., in respect of each pensionable officer, periodic contributions of such amounts and manner as may be determined by the minister by order, subject to affirmative resolution of the House of Representatives. So the possibility exists for, you cannot have contributions being made, employer contributions being made before the fund is established, because it says the government shall pay them into the fund. So if the fund doesn't exist, then you can't do that. So the existence of the fund is a precondition of the government making its contributions. On the other hand, you can establish the fund but not have the employer contributions being made into it, because Clause 10 allows that date to be determined by the minister by order, whereas the fund establishment is a separate exercise also by the minister by order. I am not sure why we're doing it this way. I'd have thought that once the fund is established, the contributions should be made into it immediately and not have two separate dates for that. My goodness me.
Well, yes, although the member said he wasn't going to be long, but nonetheless, Mr. President, the time allotted to the member to make his presentation having expired, and now move that we give him permission sufficient to
Thank you. The question is that the standing orders be suspended to allow the minister to complete, to allow the senator. Sometimes the future casts its shadow into the present. Quite often it does not.
That sounds like a plea of desperation.
Senator Golden.
Thank you, Minister, and thank you, President. I move to the next point that I wish to make. And Clause 12 deals with refunds of contributions. And it provides for example, in 12.1, if the post that the pensionable officer filled ceases to exist, and he has less than 10 years service, he's entitled to a refund of his contributions. And this is important because 12.1 is only dealing with the employee's contributions that were paid into the fund. However, there's no provision for the payment of interest on refunds. And I don't know what the reason is for that, but if somebody has had their money stashed away in a trust fund for up to 10 years and is getting it back, one would expect him to be entitled to interest on that money. If not, it represents a very substantial financial subsidy at his or her expense to the other members of the scheme. The next point I wish to make relates to vesting. There's no clear provisions in this bill in relation to vesting. And by vesting, I mean the process whereby, in accordance with the rules of the plan, which is what this act is setting up, the period after which the employee who is participating and making contributions acquires an interest, a proprietary interest, in the employer contributions that have been made for his or her benefit, so that once vested, that those contributions will go towards the purchase of a pension for him or her, or if he's leaving the plan, either will be repaid out or ported to another pension scheme, perhaps in the private sector, or pay for a deferred pension at a future date. There are no provisions in the bill around vesting and around the rights that the employee would have in those employer contributions that are referable to his or her employment. There is a provision, clause 16, that deals with deferred pensions, makes no reference of vesting as such. And it's not clear if you look at 16 whether or not, for example, if you resign having achieved 10 years or more service, you have a right to a refund of the contributions that you have made in those circumstances, or whether, because all it says is that a pensionable officer may be eligible for a deferred pension in those circumstances. I think that there's a lack of clarity around the vesting. It seems like the Act does contemplate a 10-year vesting period, but it's not, it doesn't speak to it in those terms, and it doesn't say really what the employee's rights are in relation to employer contributions. For example, if the vesting has been achieved, but the person leaves the employ of the public sector prior to retirement. And I think that is an omission from the bill, which ought to be clarified. I'm going to, as I said, I have a number of points to make. I just want to go through the bigger points first. I note this curious concept of a special early retirement program, which has been inserted in the bill in subpart B of part 12. And what I note about it is that 44.1 says that there shall be established with effect from the period commencing and ending on such date, or may be determined. There seems to be some words missing or something. Determined by the minister by order. So it seems that the minister is being given power here to set the parameters of the period in which this special early retirement program is to operate. But then, clause 50 says that the provisions of this subpart shall expire on April 30th next year. And furthermore, it requires regulations, which we're not aware whether those regulations have been prepared or not for this to operate, and so on. I hear the minister saying they have been, but we haven't seen them. I'm just saying that you've hardwired into clause 50 a date which is not far away. You know, it's around 9 months away. And this program will have to operate within that window, since you've hardwired it in the bill in this way. We don't even know when this act will be brought into effect, because there's an appointment day provision which says that the act, if you look at clause 1, the act shall come into operation on a date to be appointed by the minister by notice published in the Gazette. So the start date for this program is not going to be when this bill finally gets passed through Parliament and gets the GG's assent. There's going to be another date, which is the date that the minister decides to bring the act into effect. And then this whole subpart dealing with this special program ends April 30th, 2018. I'm not sure why the government thinks that it suits them to have it cast so firmly in stone. I wanted to make one point on the Board of Trustees in relation to the pension fund. and it concerns the investments that the fund can make. A couple of points here. In the list of securities, in paragraph 8.2, Bank of Jamaica securities are not mentioned, and they should be. And in fact, they are mentioned in 9.2 as being something that you can invest more than 5% of, but the actual list of securities that are permissible doesn't include them, so that's an oversight. But the bigger point I want to make relates to private equity. The National Insurance Fund has for some time been able to invest in areas of the economy where there is growth. So, for example, they were able to invest in what is now Malaya Braco, and they have made other investments. We don't have, as far as I can recall, any listed companies that are invested in the tourism industry, other than Sagicor, I suppose, but that's in a more indirect way. Their primary business is as a life insurer. Yeah, and they do it through their pension fund management business and their life insurance funds. I would have thought that, given the nature of our economy, it would be advantageous to allow small but important space for buying private equity. I would have suggested that we could consider allowing non-listed equities to be purchased up to a limit, I would say, of 2.5% of the assets of the fund. The general limit per security is 5% in 9.2, but since we're dealing with a more liquid form of security, I wouldn't object to having a lower limit. That's for the policymakers to consider, but I think that we should create some space to allow those. And I would also say that if you're doing it, the board should be satisfied that there's a viable exit strategy to enable the investment to be liquidated within whatever the strategic period of the investment is. So I think once the board is satisfied of that, the fact that the equities are not listed shouldn't preclude the investment being made, because you're excluding large parts of the economy. Yes, well, this is full of that. This is strong on those issues. Yeah, this is strong on governance arrangements. We made sure we put those in when we developed the bill. Yeah. Yes. I didn't. It was an oversight. Yeah. But I was reading this morning when I woke up, and it did occur to me. Yes. All right. I'm going to quickly now go through a few less fundamental issues, but things that I think should be. I want to bring them to the attention of the drafter and the policy persons so that you can consider them, especially since the minister has wisely decided that we won't conclude this today, and this will allow for some time for them to digest the issues. I think the definition of existing public officer needs to be revisited. As presently worded, it's a little unclear, and I just commend the drafter to have another look at it and see if they agree with me. In the definition of new public officer, I think the words "in the public service" should be inserted after the word "office," which is what exists, for example, in the existing public officer definition. There are some words in the definition of public service on page 4. There's some words at the end of it, "for the purposes of the provisions of this act." Those words, I don't understand what they're intended to achieve. I don't know if they're in the wrong place or what, but have a look at those words for me, please. Registered service in relation to teachers talks about entered in the register in accordance with the provision of this act. Is that correct? Is it this act that teachers are registered in for registered service purposes? I'm not sure, but when I read that, it surprised me. And I don't recall seeing registration provisions in relation to teachers in the bill. Yes. But I think service as a teacher entered in the register. I think it's probably in the Education Act that the provisions for registration of teachers are, or some such act. In 3.2, it says, except as otherwise provided, and subject to subsection 3. I don't know where it says except as otherwise provided. It doesn't say where provided. I don't know whether it means in this act or what. But it says the provisions of this act shall apply to persons who are permanently employed as pensionable officers, including constables, parochial officers, and teachers, except as otherwise provided. I think we should be clearer as to what we mean by otherwise provided there. And another point in 4.2. 4.2 says, any pension, gratuity, or other allowance granted under this act shall be computed in accordance with the provisions in force at the actual date of the pensionable officer's retirement. Are we talking about regulations made under this act? Are we talking about provisions in force? Or what are we talking, what provisions are we talking about here? I think we need to be clear on that as to how that is to be dealt with. In 11.4, there's provision for what should happen if an employee is seconded to an undertaking whose employees are not members of this scheme. So you might have, for example, a statutory body, say, that has its own pension fund, and an employee who is a contributor to this fund is seconded there. That provision ought to say that, it goes on to say that the undertaking to which he or she is seconded shall continue to deduct contributions from his salary and shall be liable to contribute to the fund as well on behalf of the pensionable officer. So, but first of all, it doesn't say that under 11.4 that the contribution shall be paid directly into the fund. I see an amendment that is being made in relation to another provision to make that clear, but not in relation to 11.4. But also, I think that if you look at 7.2, which is a list of what needs to be paid into the fund, there ought to be a reference to contributions by an undertaking referred to in section 11.4. Ought to be in that list, in 7.2. No, it's the same fund. What this is saying is if your pension arrangements continue, and so the employer at that place is required to make contributions on your behalf into the fund, and so on. So I'm saying in 7.2, there shall be paid into the fund. There ought to be a reference to contributions payable by an undertaking referred to in 11.4. It's one of the things that ought to goes into the fund. Yes. I move to clause 9. As I said before, I think the marginal note ought to have the words in trust added. Money in the fund to be held by the board in trust, because that's the key point in clause 9, is that it establishes the pension fund as a trust fund. I've already made the point about who are the members. However, if we're if retired persons who are entitled to receive pension, gratuity, and other allowances under the scheme are to be included, they either have to be included in the definition of member or added in Clause 9. There ought to be a reference as persons for whom the assets are, the property is held in trust for. So that needs to be covered one way or another. I move to Clause 11. And this is saying, as a contribution towards pensions and so on, there shall be deducted from the salary of a pension officer. And it goes on to say, and an officer employed in a pensionable post. Now, that's the first time that we are seeing those words. Pensionable post is not defined. And I'm not sure what is intended to be the difference between a pensionable officer and an officer employed in a pensionable post. But it's, as I said, it took, when I read 10.11.1, it jumped out at me because it wasn't a concept which was used earlier in the bill, and it's not a defined concept. I see it's actually repeated in the amendments that were tabled by the minister this morning. In the new 11.1, it goes on to say, and an officer employed in a pensionable post. So even with the amendment, that point still continues. And I think you're amending 11.2 to eliminate the specific 5%. And that was dealing with part salary in 11.2. But even when it comes to part salary, or you don't want to be specific as to what portion of it should be contributed. So, fair enough. 11.3, I think I ought to say that the deductions should be paid directly into the fund when deducted. It says that any contribution made under the section shall accrue daily and shall be deducted by the accountant general monthly in arrears from the salary, but doesn't say and shall be paid directly into the fund. I think it ought to say that there. And as I've said in 11.4, I think that also ought to be added, that these deductions made by these other undertakings that a person has been seconded to, if they deduct contributions from pay, they ought to pay it directly into the fund when deducted. That should be made clear as well. In 12.2 says, well, 12.1 is dealing with refunds. If somebody who has made contributions from their salary, and this is their money paid into the fund, if they leave, essentially they leave the employ of the public sector within or less than 10 years service, either because their post has been abolished or they have resigned or they've been dismissed. And subsection 2 says, in these circumstances, a pension officer shall be entitled to receive a redundancy payment computed in accordance with the Employee Termination Redundancy Payments Act. I must say, when I read that, I was surprised. I thought the language would have been something like, the payment of a refund shall not in any way prejudice a person's entitlement to a redundancy payment under the Employment Termination Redundancy Payments Act. But to positively state here that you're entitled to a redundancy payment in these circumstances is a little unusual, and I would have thought that it's creating a liability that wouldn't perhaps otherwise exist in certain circumstances. So I questioned it, and I thought the formulation should have been more one that preserves rights or entitlements rather than creates new rights which might not otherwise have existed. Because the real thrust of 12 is to say that you're entitled to a refund of your contributions into the pension fund. And I don't see why we're tying that to a redundancy payment issue. The other point I wanted to make on 12 was in 12.3, which says that for the avoidance of doubt, the refund of contributions to a pensionable officer under 1C, which is if they're dismissed from the service, shall be limited to the contributions that were paid into the fund by the pensionable officer. Now, that provision raises issues because First of all, 12.1 is only dealing with refunds of contributions paid into the fund by the pensionable officer. So in a sense, 12.3 is redundant because 12.1 is only dealing with contributions that the employee has made. But by highlighting that for the avoidance of doubt, refund of contributions under 1C are limited to contributions that were paid into the fund by the pensionable officer, it raises the question, well, does that mean that 1A and 1B are to be treated differently? And that's strange because all 1A, 1B, and 1C are all dealing with contributions that were made by the pensionable officer and which are refundable and nothing else. So the way in which 12.3 is worded casts some doubt as to whether 1A and 1B are to be treated differently, though on the face of it, it seems clear that it's only dealing with contributions that were paid into the fund by the pensionable officer. And I think 12.3 is redundant because 12.1 is quite clear that that's what it's dealing with. In 15A, this is dealing with early retirement and this transition period. The bill contemplates a transition period where the date for early retirement is moving from 55 to 60. And that's being done over, I think it's a 5-year period. And there's a monthly adjustment over those 60 months as the early retirement age goes up incrementally. And the first schedule sets out those quite clearly. If you look at 15A, it says, subject to 21, a pensionable officer may be granted early retirement from the public service by the Governor General and be eligible to receive pension, gratuity, or other allowance if, being an existing public officer, he will, during any of the months in the transition periods specified in column 1, attain the corresponding age specified in column 2. But that can't be right. It can't be that he can claim early retirement if he will achieve that age in that period. It should be if he has attained it, then in that period. I think the verbal construct needs to be corrected. And if you look at B, it uses a language of has attained. I think A should say has attained as well. 16 begs the question, can the employee elect to take a refund of contributions in this instance? 16 is dealing with what happens where a pensionable officer resigns from the public service having 10 or more years of service, or where the post is abolished at a time when the pensionable officer has completed 10 or more years of service. So, and it says that that person may be eligible for a deferred pension. I don't know what that means. Is it that the person is eligible or can elect to choose a deferred pension? And if the person doesn't want to do that, can the person elect to take a refund? And if so, does that refund also include the employer's contributions that are referable to his service? This is all to do with the same vesting issue, which is unclear, but I think it needs to be clarified. And the same point I made about the redundancy pay, which is in 12.2, is also found in 16.2. I'd have thought that the way this should have been phrased is that a payment under 16.1 towards a deferred pension and so on is in addition to any entitlement that the person may have under the redundancy payment law. Yeah. This is saying that the person shall also be entitled to. So I'm just saying, yes, it is, but I don't know why, if, okay. That's the all right, okay. Senator Brown has explained what he thinks is the reason, which is that it is applying the employment statute to the public sector worker, which would not otherwise apply. All right. That was in the bill from we did. So I'm not giving you kudos for it. But the formulation, on reflection, I thought the formulation should have really been one that was permissive rather than mandatory, but I now recall the reason. 17, where the pension officer dies, I think the words "while in the public service" should be there. Where a pension officer dies while in the public service before attaining the normal retirement age. 17.1. Yeah, 17.1. I think that there ought to be a reference to section 27 here, because this is saying that a gratuity may be paid to his legal personal representatives, but section 27 speaks to a similar situation where a pension officer dies while in the public service and says that a gratuity of an amount not exceeding either 1 year's pensional emoluments of the officer or his commuted pension gratuity, whichever is greater, may be paid to his legal personal representatives. I think the two ought to cross-reference each other. And the question arises, is this payment of the commuted pension gratuity in addition to the refund of his contributions under 12.4, where he has less than 10 years service? It's not clear, because 12.4 is suggesting he's entitled to a refund. So is this in addition? Is this commuted pension gratuity in addition to the refund or in lieu of it? I think that should be clarified. In 17.2, it says the provisions of subsection 1 shall not apply to a pensional officer who left the public service on such date as may be determined by the minister by order, unless he has once again. I'm not sure if that is intended to mean that you must have left it on that date, or you have left it on or before that date. I think it's meant to mean on or before, whatever date the minister is going to prescribe there, but it says on such date. So that perhaps could be clarified. I must say I found the whole of 17.2 a little bit opaque. I wasn't sure what it was trying to achieve, but I'll move on. In relation to clause 20, where it talks about the Governor General may, in certain circumstances, grant pensions, etc., as he thinks just and proper, it's not clear how that relates to the fund. I think it's saying that these circumstances, for example, retirement in the public interest, under the employment arrangements in the public sector, it's the Governor General who would make the decision whether or not to award a pension. But I think it ought to be made clear that these payments are made out of the fund, because it almost sounds like this is something separate to the fund. And I think that should be made clear. In clause 23, dealing with police now and constables, it says that, subject to subsection 2, a constable may be granted early retirement from the force and be eligible to receive a pension, etc. Is it that it's a discretionary thing, early retirement in the case of the constable? Why is it say may be granted as opposed to shall be entitled to? Is it not a matter of entitlement? I don't know. I asked that question because of the way it's worded. In subsection 4 of 23, there's a reference to subsection 4, which I think is a wrong reference. The provisions of subsection 4 shall not apply. I think that should be a reference to another subsection, because it appears in subsection 4. Moving to clause 32, and this is to do with these relevant children. I see that there's an amendment being made, but I was wondering then in 32.2c, where it says every pensioner officer who shall marry has to notify the ministry, etc., in writing of the name of his spouse, the name of the marriage, and if there's a stepchild, the name and date of birth of that child. But if that child is not a relevant child within the meaning of the definition, is it necessary to notify the employer about it? I think it would be if there's a stepchild who's a relevant child, in other words, a child of one spouse who's accepted as one of the family by the other spouse, as defined here. It just seemed to me to be inconsistent with the scheme to require notification of a child that was not a relevant child. In the general transition provisions, on page 22, clause 42, this is saying all persons who immediately before such date as may be determined by the minister by order were receiving a pension shall continue to receive those benefits. This is excluding persons who are already earning pensions from the scheme of this act. But I think that date and that order ought to be subject to affirmative resolution of the House, because it's a very fundamental decision, because that whole entire class of pensioners will not come under this system and will stay under the old system. And I think it's sufficiently important that the order there ought to come to Parliament for approval. That was 42.1. In 42.2, it says that for the avoidance of doubt, it is hereby declared that the service of all existing public officers prior to April 1, 2016, shall be taken into account for the award of pension, gratuity, or other allowance granted under this Act. I'm not sure what the relevance of that date is. I don't think that must be an error. And I don't know whether it should be prior to the commencement of the scheme or prior to the Act coming into effect or what. But there's the date, April 1, 2016, which was the original planned start date for contributions, but has been abandoned. That needs to be fixed. It's in 42.2. 43. All existing public officers and their dependents and persons claiming through them shall, upon such date as may be determined by the minister by order, continue to be eligible to receive benefits which they were entitled to under the provisions of the Civil Service Family Benefits Act, as if the Act had not been repealed. But I think there's some words missing there. I think that it ought to say that all existing public officers and their dependents and persons claiming through them shall, if upon such date as may be determined by order by the minister, were eligible to receive benefits under that Act, that Civil Service Family Benefits Act, they shall continue to be able to be entitled to or eligible to receive benefits as if the Act had not been repealed. It's only if they were, at whatever date that was, they were then receiving or entitled to receive that those rights are preserved. The way it's worded now seems a bit odd. Any pensions payable to persons? Yes. In this special early retirement program, Minister, any pensions that are triggered by persons taking advantage of it and retiring early, what are the arrangements that will apply in relation to the payment of those pensions? Are those going to be under the old system? Presumably, because the fund won't have been established. But I wasn't sure how that fitted in with clause 42. I think it might have been useful to just make that clear. And the other point I want to make is that where it talks about in 45.2, where it talks about the requirements are that the existing public officer is between the ages of 50 and 59 years, I think there needs to be something that clarifies when that is being determined. In other words, is it that the person must be between the age of 50 and 59 years as at the date of his application to come under the scheme? That would seem to make sense. I think we could perhaps just add those words in 2A. Is between the ages of 50 and 59 years as at the date of his application under subsection 1B, which is the provision that allows him to make an application to the Governor General expressing a wish to take advantage of this program. And in 47, it says an existing public officer who retires from the public service under this subpart shall no longer be eligible for retirement under any other enactment. Is that what it seems odd to me to say no longer eligible for retirement under any other enactment? Is that what it's supposed to mean, or is it eligible for benefits under any other enactment? If he's retiring, he's retiring. And if he retires under this subpart, certain consequences flow. I wasn't sure whether the words eligible for retirement made sense there. And once again, I point out that that specific date of April 30th, 2018, in clause 50, maybe you want to consider having some provision that would allow that date to be adjusted if things take a little longer than you had anticipated to get it going. Other points to note, in the second schedule, the fit and proper requirement for trustees of this board includes tax compliance. That I just want to highlight, I've never seen that in a fit and proper formulation before. I don't know if that's heralding a new day in this, in where we're going with these things. But in the financial sector, for example, or in the this is banking or securities or other areas of our law where persons must be fit and proper, we have never had a tax compliance requirement. Yeah. I'm just notifying that that is what it requires. And then in paragraph 4, the 3-year board appointment, I don't think, that to my mind is too short. I would prefer, these are trustees, I would prefer a tenure which spans at political administrations, like a 7-year thing, not a 3-year appointment so that you have a rapid turnover of the trustees of the fund. The trustees must be persons who are, well, fit and proper, as we've seen, and they should serve for a reasonable period of time. 3 years seems unduly short. And then I noticed on the next page, in 4.3 says, notwithstanding anything to the contrary, the minister may at any time revoke the appointment of any member of the board. But that seemed an odd provision, given that there are specific detailed provisions about the circumstances in which an appointment of a member of the board can be revoked. If you look at 1.5 has a list of, on page 28. So 1.5 says, towards the bottom, that appointment of a member of the board may be revoked for physical or mental infirmity, bankruptcy or compounding with or suspending payments to creditors, being convicted of an offence involving dishonesty, or any one of the more offences listed in the POCA second schedule, or no longer meeting the requirement of being a fit and proper person, or engaging in activities that may be reasonably considered prejudicial to the interests of the board or the fund. That seemed quite comprehensive, and I wasn't sure why we were retaining a further ability to revoke an appointment, even if those criteria aren't met. That seems to be an inconsistency. Sometimes we give this power to a minister where we don't have criteria set out. But where the criteria have been detailed, then if those are met, revocation is possible. If they're not met, there shouldn't be revocation. I don't think 4.3 belongs in the bill. And if you look at page 31, paragraph 8, that seems to have just been a cut and paste job from some university statute and needs to be fixed. It makes reference to the council and the statute and the university and so on. So just fix that one up for us, please, if you would. On page 32, it says that the board shall, in 3B, give consideration to the impact of expenses on the return on investment by keeping costs to the fund at a minimum. I don't like the words used there. I think it should be as low as may be prudently achieved or something. Requiring the trustees to keep expenses at a minimum means that you may be cutting corners on things like the advice that you're getting, the quality of the advice that you, and so on. I think the trustees should be, get value for money But I don't think that they should just be mandated to keep costs at a minimum. I think there should be some prudential requirement around that. And I suggested words like as low as may be prudently achieved would be appropriate there. And in 8, on page 34, the board shall make investments through or place deposits in financial institutions that are licensed either under, this really should say make investments through financial institutions that are licensed under, by the Financial Services Commission, or place deposits in deposit-taking institutions that are licensed under the Banking Services Act. The way it's lumped together is not right, because they shouldn't be making investments through the bank. The banks are not in the business of making investments for clients. That should be done through a dealer that's licensed under the Financial Services Commission. On the other hand, if you're placing deposits, that should only be possible through a deposit-taking institution that is licensed under the Banking Services Act. In the question of foreign currency holdings by the pension fund, that is dealt with in 8.4. And it says the fund shall not in the aggregate hold an amount exceeding 10% of its fair value in assets denominated in foreign currency without the prior approval of the minister. I think that given you're dealing with foreign currency issues, it might be useful or appropriate, I would suggest this, that the minister should consult with the governor of the Bank of Jamaica before giving approval, because you're talking about a very large fund, potentially down the road. It's an entire public sector fund. I'm not sure, because that probably applies to approved pension schemes, which this is a different system. So I think, and this is setting a 10% limit. I don't have a problem with that initially, and it's allowing for a mechanism by which it can be increased. But I do think that the minister ought to consult with the central bank governor before making an adjustment to this, because that's how the Bank of Jamaica Act typically works in relation to, even for example, the same point you're making about Section 22A, B, and C, so on, the directions and so on that are made by the minister are actually made through the Bank of Jamaica. So I think it would be useful to tie that in. Mr. President, I've completed what I have to say on this bill. As I just recap by way of the original point I made, which is that this bill is dealing with a very difficult problem that the nation faces, the problem of financing pensions in the public sector. There are no easy solutions to that problem, and it represents a series of compromises to try and get to a manageable situation that will avoid the problem deteriorating further by shifting some of the burden off of the budget for dealing with pensions. And it will take a long time before we are able to do that to a very meaningful extent. There are some issues that we have raised with the bill which we hope will be considered, but overall we support the thrust of this legislation as we recognize how important it is to the country. Thank you very much.
Thank you, Senator Golding, and I noticed that you dealt with most of the matters that you had promised to deal with in committee. You just dealt with everything one time. It's appreciated. I doubt you should have. Senator Webby.
Well, we should have a short committee meeting. Thank you very much, Mr. President. Permission to speak from a seat.
Thank you. Go ahead.
I learned very quickly from you, Mr. President. The last time I had my ID showing. Mr. President, thank you very much, and thank you very much to our colleagues. I thought Senator Reid and Senator Golding went into a fair amount of detail in terms of their presentation. And I agree with you, Mr. President. Our committee meeting should be very short after that detailed review by Senator Golding. Mr. President, I rise to support the two bills being debated today, namely the Pensions Public Services Act 2017 and the Constitution Amendment Establishment Fund Payment of Pensions Act 2017. Mr. President, when passed in law, these bills will make way for public sector pension reform. Mr. President, before going into my presentation, let me move this chair away. Yes, tight quarters. Now I understand why you do that. Mr. President, before getting into the details of my presentation, I want to firstly recognize in my presentation today all the public sector employees who have worked hard to offer technical assistance and support for the draft of these bills. Mr. President, pensions, as you have heard, is a sensitive issue as it concerns an employee's compensation package. Mr. President, arriving at this juncture in pension reform required, and you heard it very clearly from both presentations, required a delicate balancing act in light of our tight fiscal space and the debt imperatives. And this has called for sacrifice on the part of all stakeholders concerned. Mr. President, I think I should thank the unions, the associations, and other stakeholders that have cooperated with both governments, in sitting at the discussion table to come to an agreement on the way forward regarding public sector pension reform. Mr. President, I know that some public sector employees are already contributing to their pension, such as members of parliament, which I understand is at 6%. But I want to recognize the sacrifice of public sector employees whose disposable income will surely be impacted. Mr. President, the government should also be commended for its response to the concerns raised by stakeholders during the discussions on the way forward. The amendment that followed the discussions are quite welcome, and it shows that we can achieve what we set out to, paving the way for a more comfortable and decent retirement for hard-working public sector employees. The amendments that followed the discussion include, for example, removing the penalty for early retirement and phasing in of the 5% contributions. This process of pension reform started some time ago, and a number of options for reform have been considered. We have had technical assistance from the World Bank and other stakeholders, which contributed during the Joint Select Committee's review of the Green Paper on pension reform. And I think, Senator Golding, you're part of that Select Committee for the Green Paper reform. In particular, the World Bank assisted the government of Jamaica to carry out diagnostics to undertake pension reform. Mr. President, based on the Joint Select Committee's report on the Green Paper, the 2011 projections for pension payments stood at 1.4% of GDP, or about 5% of total government revenue. The assessment of the state of the system found further that public pensions payment would continue to increase in upcoming years. These figures and subsequent projections indicate that the system was becoming unsustainable and consequently would have serious implications for the country's already growing public debt. It was also noted that public sector pension is an implicit liability or a contingent liability of the government of Jamaica and therefore not accounted for in any public sector balance sheet, although it can be measured. Without the contingent pension liability factored in, Jamaica's public debt at the time stood at 129% of GDP. The implicit pension debt was estimated at around 20% of GDP. This contingent pension debt was expected to grow significantly unless steps were taken in time to contain it within sustainable levels. So, Mr. President and colleagues of the Senate, I think we'll all agree that the current situation would really be unsustainable. The White Paper on Public Sector Reform, tabled in the House of Representatives in December of 2013, highlighted the unsustainability of the pension system within our macroeconomic framework and consequently the necessity for reform. Mr. President, I quote, "The reform of the public sector pension system was born out of the recognition that the current system has become fiscally unsustainable, thus rendering it unaffordable. This means that because the government's expenditure is in excess of the revenues collected, money has had to be borrowed from various sources to finance the gap between revenues and expenditure. This has resulted in a current high level of debt to GDP, which is unacceptable. It is within this context that many challenges being faced by the Jamaican economy that reform in the public sector pension system is a critical element in getting the economy back on a sustainable path of growth. Mr. President, I'm sure that based on these facts, we will all agree in this Honourable House that the reform of the pension system is an economic imperative. Mr. President, I said it here and I'll say it again. The IMF is not the solution to Jamaica's problem. The IMF is not the solution to Jamaica's problem. So, Mr. President, this is not about the IMF or whether pension reform is or was an IMF benchmark. To me, that is secondary. It's about us exercising fiscal discipline as a country and bringing our debt under control. Pension reform, if you look at Vision 2030, Mr. President, states that the national strategy is to promote greater participation in and viability of social insurance and pension schemes. Mr. President, if we were to continue business as usual, the quality of retirement of public sector workers would be in jeopardy because of the likely inability of the government to pay pensions in full and in time due to lack of funds. The government faced with this crisis would be faced to borrow to pay public sector workers as a move which runs contrary to the maintaining stable macroeconomic conditions and reducing our debt and growing the economy. Mr. President, I don't believe that these pension reform bills are the silver bullet to containing the pension bill and making the system administratively efficient. However, it is a start to managing the government's obligation in a more fiscally sustainable manner. Going forward, we have to consider further reforms to the pension system to strengthen it, increasing transparency, and ultimately securing a decent standard of retirement for hard-working public sector employees. Mr. President, I'm going to make a recommendation which may be controversial, but I believe it's fiscally prudent, and I think Senator Golin touched on it quite well. Mr. President, most private sector organizations that had defined benefit schemes have discontinued or phased them out for defined contribution schemes because defined benefit schemes are expensive to maintain. And in fact, there are case studies where defined companies have gone bankrupt because of the maintaining of defined benefit schemes outside of Jamaica. I understand that the policy is currently that the defined benefit scheme, which is constitutionally protected, is to be maintained. While I support, Mr. President, not changing the current defined benefit scheme, we may need to look into creating a defined contribution scheme for new employees and a grandfathering mechanism for employees under the defined benefit scheme. This would help to cauterize the government's future pension liabilities. Mr. President, I will now say a few words on the issue of the segregated funds, which sometimes can be quite controversial. There's currently no discrete fund set aside from which pension payments are made. Pensions are paid on a pay-as-you-go basis from the consolidated fund. So what we have is an unfunded pension system. Mr. President, I would like to place on record that I'm in full support of the segregated fund being established at a point in time when we have the fiscal space to do so, and for the government to start making its contribution at that time. There are a number of advantages of a segregated fund, and organizations such as the OECD have expressed support for this approach and identified benefits, and I'll share some of the benefits with this Honourable House, Mr. President. The first one is less scope for political interference in the management of the fund. Key decisions such as strategic allocations are decided by autonomous entities at arm's length from government. The second is focuses on investment of the reserve funds of assets rather than on achievement of policy goals. So there is a greater clarity with respect to the mandate and objectives of a fund compared to if the government has direct control. And three, and most importantly, greater transparency and accountability. The focus on investment raises the visibility of the fund's operation and allows an effective measurement of the fund's performance. Mr. President, there are some other issues that I'd like to make mention of that I believe are important to continued pension system reform. They are portability of pensions, the vesting period, and indexation of pensions. Mr. President, it is my view that non-portability of pensions and long vesting periods make working in the public sector less attractive to young people and private sector workers who would like to devote a period of time to national service. Mr. President, the current system does not provide for portability, only for an employee to get a refund of pension schemes, the pension contribution. As far as I'm concerned, Mr. President, it's a disincentive for persons who wish to move into the private sector. Portability of pensions is also very important in the context of the discussion that we're having now in terms of rationalizing the public sector. Because in my mind, the workers that may be displaced from the public sector will find jobs in the growing private sector, and the portability of the pension scheme would be a big plus for all. Mr. President, I'm suggesting that we seriously consider this in the future. Seriously consider this in the future. So in other words, someone leaving the public sector would be able to transfer their accumulated benefits to the private sector scheme, and vice versa. The second issue is that the vesting period stands at 10 years, and I think Senator Golden spent some time on that. I believe that at some point after the segregated fund is established, we should look into reducing the period to 5 years, or introduce a grade investing system, for reasons I mentioned earlier. Mr. President, I move to the other issue of indexation of pensions. And I know about this quite well. And I heard Senator Reid in his presentation make the comment about children can no longer afford to support their pensioners or their parents who became pensioners. Well, I will share with this honorable House, Mr. President. My mother, before her passing 2 years ago, was a teacher at St. Andrew Technical High School in Marcolet and Campion, teacher for 50 years. And her pension at the time could not pay 1 month's light bill. Could not pay 1 month's light bill. And this is a discussion that I feel pretty strongly about for that reason. Mr. President, without our current economic realities, without indexation, pension payments can quickly become inadequate to cover the retirees' expenses during retirement. And I just gave you a personal example. My understanding is that at this time, pension increases are granted on an ad hoc basis through appropriations from the budget. Indexation of pension should be standardized to avoid ad hoc increases, and it will allow for transparency and better predictions. It should be indexed to inflation or the growth in wages. However, it must be borne in mind that indexation must be subject to affordability and be based on proper actuarial valuation. So I'm throwing it out, Mr. President, for discussion. So, Mr. President, in relation to the issues I raised, I would also want us to carefully monitor how the current reforms work. And in reading clause 38, I see that there is going to be a joint select committee, if I'm correct, Minister Reid, for no later than 2 years, where we have a sit-down review. The other point that was made by the PSOJ, of which I'm a member in the Joint Select Committee, was that we need to have an education, a sensitization program, so that public sector workers, Senator Brown, can understand what these reforms are and the implications for them. So I would also want to recommend that we have a structured communication strategy to the public sector workers so they can understand very clearly the impact of these changes on their pension. Mr. President, in closing, my observation is that these bills show a level of maturity as a country in terms of fiscal discipline. And in fact, I'll share with this Honourable House. Yesterday I was in a meeting of foreign investors, private sector investors, Senator Brown. And they were very complimentary of our country, of the continuation of successive government in terms of our seriousness of fiscal discipline. And I think that is something that we should never take for granted. And on both sides, Peter Phillips deserves a lot of credit, and so does all the Shaw, in terms of continuing the process. But I can tell you, in terms of investors and the private sector, this continued seriousness about fiscal discipline, I can assure you, is going to reap significant investments in the future. And what it shows, Mr. President, is what I've always believed, that we can work together to achieve what is best for our country, and this has been demonstrated here in terms of the discussion on this bill. The last thing that I'll say, I've said it before, but I need to repeat it. I've had the opportunity, and I consider it a great opportunity, to work in the public sector for 2 years with some of the best minds and talents in our country. And I'll continue to say that. Mr. President, I will close by also saying this, that we must ensure that the decisions we make that affect them will keep them motivated to give great service to our beloved country. Thank you very much.
Thank you, Senator Webby. President Morris.
Thank you very much, Mr. President.
That's not the future casting in Strada. That's a retroactive compliment.
Mr. President, I rise to make my contribution to this debate on this bill. And just to say to Senator Webby, you know, I know you served in the service for 2 years, but I was very disappointed when you left. Mr. President, the bill before us, an act to establish a contributory pension scheme for the public service to be known as the Public Service Pension Scheme, from which payment of pensions, gratuity, and other allowances are to be paid in respect of the service of pensionable officers and to provide for other related matters. Mr. President, in general, I give my full support to this bill in terms of where I see us going. And I say so, Mr. President, because the truth is we have to make sure that measures are put in place to accommodate the growth and development of individuals in their senior years. And individuals have to start making that preparation. And what I see happening in terms of this legislation is a mechanism to allow for employees in the public service to contribute to that process. And I say, Mr. President, I heard Senator Webby asking for a communication program to be put in place to sensitize members of the public service as to the reforms that are taking place where this piece of legislation is concerned. And I agree with him wholeheartedly, because there tends to be the view, Mr. President, that contributory schemes such as the one being established under this legislation is really a tax on the people. And in that context, individuals are very ambivalent towards some of these initiatives. And I believe that one of the things that should be done in going forward is that I know that when you get your pay slip, your pay advice, it spells out the different deductions that are there. But I think a line or so or two should be placed at the end of these pay advice indicating that upon retirement you are entitled to X, Y, Z. So it would point out that you are entitled to your regular pension as a public servant, you are entitled to your NHT benefit, and you are entitled to your NIS benefit. And I think that every month that would be going out on your pay advice, so people would see it and know that this is something that I have set aside for my future years. And speaking of the NIS, Mr. President, I couldn't stand here today in my contribution without making reference to that particular pension fund, because all workers in Jamaica have contributed to it, and all the workers are entitled to the benefit. And I was particularly struck when Senator Webby mentioned the whole situation of indexing, that the plight of our current NIS pensioners. And I take note, Mr. President, that in recent times, the government announced that it made some $14 billion from the NIF for 2016-2017. And they have indicated that they will not be paying a benefit, any increase to the pensioners, because the actuarial review is currently being pursued, and there are some challenges with the fund. But you know, Mr. President, if it is that you make $14 billion from that fund, and recognizing the challenges that these pensioners are undergoing, I think it is only fair that some consideration to be given to an interim payment to these individuals until the actuarial review is completed. You know, because the last time these individuals received any increase was in 2013. And we have seen, it's the first time, you know, Mr. President, I am seeing the IMF exercising and demonstrating greater sensitivity to the most vulnerable in our society than the government, because they are saying that the government must make sure that they put in place measures to protect the most vulnerable. But we are seeing a situation where the pensioners who have contributed to the NIS have not gotten any increase within the last 4 years. And I think that that is a matter that the government should reconsider. Mr. President, as I went through the legislation, there are some things that have struck me, Mr. President, and one of them I know that you are going to give me a lot of support on later on. In particular, Mr. President, in Clause 8, I note in Clause 8 it says, the board shall be responsible for A, the management and control of the fund in accordance with the provision of this Act and any regulations made hereunder, and B, the policy and general administration of the fund. Now, Mr. President, I support this, but I heard the Honourable Minister stating that there will be an amendment to allow for the Minister to formulate policy as it relates to the surplus of the funds. And that to me is concerning, because I have seen in recent times where a number of state entities have generated surpluses, and those surplus are now being taken away from those entities and find its way into the general consolidated fund. So I wouldn't want to have a situation where, surplus from the pension fund, the minister makes a policy that those funds should be handed over to the government for whatsoever reason. So I think that that is a matter that is concerning, concerning to me. In part 6, Mr. President, the section relating to the pension of constables, but I treat it in general because of its broad implications. And it says, A, on medical evidence to the satisfaction of the Governor General that he is incapable of discharging his duties efficiently by reason of any infirmity of body that is likely to be permanent or any infirmity of mind. Mr. President, for me, this is very important, because what it is speaking to is individuals being medical boarded and retired from the service much earlier because of some form of disability. And I'm raising it here, Mr. President, because it's a red flag for me, as cases have come to me in the past where persons with disabilities in the public, individuals have developed a disability in the public service, and they have been forced to retire because they developed the disability. There was one case where a couple of years ago, this gentleman was diabetic. He went to work, and there and then he became blind because it was sudden, it was really instant, and the individual was asked to accept early retirement. And I spoke to them about it, including the individual, and he came under a lot of pressure and ultimately signed. But, Mr. President, I make mention of it because in today's day and age where technology is playing a critical role in terms of the transformation of the lives of persons with disabilities, you can simply reroute the individual to other areas where they can function in the service, so they can continue, rather than making a 50 or a 55-year-old individual going home to sit down for the rest of their life because they have developed some form of disability. And I think the time has come for us to revise the whole approach as to how we medical board individuals, because with the advancement of technology, persons with disabilities can perform effectively in the workplace. And so I want to ask that this matter be treated seriously. Mr. President, as I went through the legislation, I saw the use of the term fit and proper, which, in its definition and its outline was really instructive to me, and I would commend members of this honorable chamber to look at it, because, Mr. President, in an era, at a time when I hear individuals are talking about the need for greater transparency, accountability, and probity in terms of public life. All individuals who we are placing on board, we have to make sure that they are fit and proper, right? And I hope that in going forward, this will be the gold standard, the gold standard to make sure that individuals who are appointed to boards are fit and proper. Fit and proper covers a whole lot of things, including that, Senator. Mr. President, I want to turn to a matter that I think would be very much interested to you. Mr. President, and in raising this matter, I want to look at some definitions that have been cited in the legislation. And it states that a pensionable officer means an existing public officer or a new public officer. All right? And then, it also states that salary means the salary attached to the office held by a pensionable officer, and B, in relation to an existing public officer where an arrangement is prescribed for taking service in a non-pensionable office into account as pensionable service. The salary attached to that the salary attached to that non-pensionable office. And I raise this, Mr. President, because of the situation relates to the office of the President of the Senate. Because the President of the Senate is a public office, and the President of the Senate is a public. No, I am defending the President. The office of the President is a public office, and it goes with a salary. All right? Now, I make mention of it because I got a letter from, no, it's not a voluntary job.
Senator Morris, I think you should let them know what the salary is.
Well, I'm coming to that now,
in case
Mr.
they think it's a
President.
real salary.
I'm coming to that, Mr. President. I got a letter in 2013 when I became President of the Senate. I got a letter from the Parliament, and it said, "Dear President of the Senate, please be informed that your annual salary and allowances are as follows. Basic salary, $56,550. A whopping $56,550. Entertainment allowance, a whopping $2,000. Total salary, $58,550 annually, and this is annually. All right? Now, when you do a disaggregation on a monthly basis, it comes out at below $5,000 per month for the salary for the president. $5,000 per month. The minimum wage is about $6,200 per week. And the salary, as stipulated in the letter from the Parliament, for the President of the Senate is less than $5,000 per month. it is,
Can we join Senator Brown Union, you think?
in my estimation, Mr. President, it constitutes a violation of the Minimum Wage Act. Violation of the Minimum Wage Act. And it is a matter, well, you know, you would render the president bankrupt if he hires a lawyer, and then he would have to vacate his seat. And we don't want that. We don't want that. So I would suggest that somebody volunteer on his behalf. But Mr. President, you know, I had to raise it because I did some checks to find out what implication this has for the pension of the President of the Senate. And if the President should retire after granting his service to the country, he would end up taking home on a monthly basis $3,500 and something. That is what you require individuals to make sacrifice for the country, and then he will end up getting that as his pension. And I think, Mr. President, as we are engaged in pension reform, we have to look at the salary mechanism for these individuals to make sure that when they retire, they are comfortable because they would have made a sacrifice for this country. And I tell you, I speak because I know, Mr. President, you in coming here to preside over the Senate have to go into a whole lot of preparation. Because you're not just there knocking the gavel and guiding the proceedings of the Senate. I am certain that you are there, you prepare, you monitor, you look at, you examine the bill to make sure that they are in order. And well, I have no reason to complain about the president. I have no reason to complain about the president.
Will you please stop barracking the speaker?
Thank you, Mr. President. Thank you, Mr. President. But I believe that it is a matter, Senator Reid, that you have to take up with cabinet, because this can't continue. Right? I was told by the former President of the Senate, Syringa Marshall Burnett, that these adjustments were last made in probably the 1980s. You know, that is something like 30 odd years ago. So whilst other adjustments have been made to offices in the public service, that of the President of the Senate is languishing. And I here submit that it constitutes a violation of the Minimum Wage Act, and it should be corrected. Mr. President, I also, in closing, I have to commend Senator Golding in the presentation that he made this morning, you see? And one of the things that I took note of is how he pointed us to the constitutional amendments that are being made and the implications that it has for us going forward. And one of the things that struck me in his deliberation was that, you know, it was said that individuals in the public service are not paid market rate salary because they are provided a pension by the state. That's right. Now you are asking them to contribute to this. And the question that it begs me to ask, are we now going to see a simultaneous shift in their salary towards market forces in light of the changes that are being made to the pension arrangement? And these are some serious things that we have to examine as we intensify the discussion about pension reform. And as I take my seat, Mr. President, I have to say that I am a bit disappointed that we are advancing the debate on the pension reforms or on this bill, and at the same time, discussions are still being held with the critical stakeholders. And it is not the best way to go, because you would have thought that you would have done the consultation, get the stakeholder buy-in, and then you come to the Parliament with the necessary amendments. Because what if in next week you should go to the consultation or discussion with the trade unions and they tell you that they are in disagreement with certain things because of what Senator Golden pointed out about the constitutionality of the legislation? You would end up into serious problems. So I believe, Mr. President, that we need to look seriously on how we approach this thing. Consultation should take place before implementation, not implementation and then consultation. It's a matter of putting the horse behind the cart. And so, Mr. President, with those observations, I want to commend the approach in terms of us going towards a pension fund where individuals in the public service will make their contribution. May it please, Mr. President.
Thank you, President. Thank you, Senator Morris. Excellent presentation. I know. Senator
President, I'm sure the last presentation, so I would find great favor with you. And I hope at some point Senator Golding will equally raise the matter of the very poor salaries paid to members of parliament and ministers. But I leave him in his further presentation to raise that matter. Mr. President, we intend to, at the moment, suspend the debate on these two bills.
Do you have a date for the continuation?
Well, Mr. President, in lieu of the fact that...
Yes or no?
But I'm making the point that in lieu of the fact that next week, is the next week Friday is a state funeral? I'm not...
So for a date to be determined?
Yes, I'm saying for a date to be determined.
So the question is that the debate that we begun today on the Pension Reform Act be suspended for a date to be fixed. In favor? Against? Any other business?
Mr. President, we would move for the continuation of the State of the Nation debate, and today we have a presentation from Senator Carinthia Morrison.
Thank you very much, Senator Reid. Senator Morrison.
Mr. President, it is with pride that I rise to make my contribution to the State of the Nation debate. I thank God for enabling me to this awesome position of responsibility. To my three brothers, one of whom is here, Kareem, and the others, Gavin and Franz, who I know are glued to their television. I thank you for your unwavering support. I'm your sister. It is expected. I I also acknowledge my relatives and friends who have invested confidence in me. To the family of the Jamaica Labour Party, my colleague senators on this side, you have given me your tremendous support, and in particular, I am grateful to the strong women in my party who have been constant in guiding me. My regret this afternoon is that my darling mother, who is no longer with me, it was her dream and that of my paternal grandmother, to sit and picnic talk in a House of Parliament. And I am happy to have it recorded that my mother was absolutely awesome. I like to call myself Miss Carmen, one daughter. May I do well today to honor her memory. Mr. President, this year Jamaica celebrates 55 years as an independent nation, and what a journey it has been. This journey has been marked by challenges, duress, uncertainties, but Senator, undeniable are the fact that there were huge successes. There is no turning back for our nation. And even as we celebrate Jamaica 55, it is also a time for us to accept our failures, seek to better ourselves, and also to confront our challenges. And this administration embraces this. The opinion of the world is that one of the most beautiful islands with fantastic weather all year round is Jamaica. In fact, one individual was moved to poetry when he said that when God was making heaven, a piece of it fell on earth, and that piece was called Jamaica. And so, visitors cannot get enough of our scenic country. Some nations would tell us that with our sun, sea, and rum, we have it all, plus our vibrant culture. Minister of Culture, Gender, Entertainment and Sports, the Honourable Olivia Grage, proudly states that our culture and creative industries program is a reminder that our human and cultural capital are unmatched. Despite our size, we have given the world cultural experiences and icons that no other country can boast. We are at a point in our development that calls for us to create an enabling environment for each Jamaican to share in a cohesive culture, apply cultural knowledge for social development, and to create goods and services within which we can have sustainable and profitable industries. Mr. President, it is against the minister's vision that I will justify her call for an inclusion of the local economy in driving our culture and creative industries as we become increasingly popular on the international scene. More and more visitors want to leave the confines of our resorts to explore and enjoy the appeal of the local culture, and this we must afford them by improving our brand. While we commemorate our history and achievements with the various festivals, galas, and other celebratory activities, we want to impact the lives of our people and also that of visitors to our shores. It is critical for them to believe in and also be stakeholders in selling brand Jamaica. Therefore, Mr. President, tourism and culture cannot be isolated from the people. In fact, what makes both attractive is the people. Culture is not pageantry. Culture is not grandstanding. It is not a party every year and then business as usual when it is over. Culture is who we are and everything that we do. It must be felt. Culture must be felt from riverside to mountain in every community. Everywhere in Jamaica should evoke an aura that this nation values its history.
Mr. President, the time being now 1:20, I move that the sitting of the, that the standing orders be suspended, such that the sitting of the Senate can continue to come. to complete the business.
Thank you very much.
The business of the day.
The question is that the standing orders be suspended in order to allow the Senate to sit beyond 1:30. In favor? Aye. Against? Continue, please. Sorry to have interrupted you.
No problem.
Senator Morrison.
Thank you, Mr. President. Other nations, France, China, the United States of America, the United Kingdom, they revere their culture. And when we look at how they treat with their historical landmarks and monuments, for example, one has to stand afar off to take pictures. You can't even get near it to touch it. Hallowed in preservation is their history. Back at home, sometimes we shudder at the poor upkeep or total lack thereof of our landmarks. In my hometown, Spanish Town, what is there? By way of how it is marketed to show that we hold sacred the fact that the proclamation of our emancipation was read in Spanish Town. This area in Spanish Town, Emancipation Square, one of the most enviable of its kind in the world. This area should be teeming with visitors, packed with tour buses. Where are the dancers? Where are the drummers? Where are the local shops? Where are the craft and gift shops in Spanish Town? To mark the landmark, we can ask so many of our politicians who have run Spanish Town for years. The surrounding communities should have been among the most sought after for residents and for business, but it is there as proof that neglect can and have hurt us. The future cannot continue in this reality. Mr. President, we must preserve the footprints of our ancestors in our culture. They gave us everything so that today we can work, play, and live off their legacy. A legacy so rich, a legacy so enviable, from which we can flourish and prosper. The blueprint for our wealth lies in the island itself. Even the medicine to secure our health lies in the soil of the island. Jamaica represents gold. I am happy that under the Jamaica National Heritage Trust, the trust which is responsible for the preservation and protection of the material wealth of Jamaica, there's an urgent mapping of sites for protection. Among the list of those prioritized is the Blue Lagoon in Portland, whose aesthetic and historical value can rival similar sites in the hemisphere, and will also ensure that no illegal development takes place within the boundaries of the Blue Lagoon. We, as a nation, should look forward to cafes, restaurants, parks, etc. within the proximity of some of these sites, which can attract thousands of visitors. This is a dream that His Worship the Mayor has for downtown Kingston. Cruise ship docked in the harbor, visitors scrambling for a taste of the island. And Mr. President, this is where I know you are all excited. Hold on a minute. And this is where locals. Yes, man. I'm going to keep you excited, don't worry. And this is where locals would benefit directly. Locals would benefit directly from the industry. Locals could register, go through the protocols of operating their business. Visitors, for example, would say, the best confectionery that I had was at that charming cottage near Lover's Leap. Might have been Greater Cake or Gizzada. Whatever it was delicious. I should be able to say, Senator Reid, I should be able to say, meet me at the coffee shop by Old Iron Bridge in Spanish Town. We would want to see our parish boundaries, for example, being connected to history. So we would have Welcome to St. Anne, the home of Marcus Garvey. So we tighten, we're all over Jamaica, we feel it. And this is because the entire island is full of history and the entire island can be marketed for tourism. Bring in the locals. Mas John can supply the coconuts to that big restaurant. Miss Jane can sell our straw hats to a particular resort or has a license to operate on her own. Mr. Sears can market his hand-milled goat milk soap. Whatever it may be, the locals can be in on the money. Mr. President, we must work to improve the optics by creating the ambience, not only in the resort towns, because this would be like cleaning the veranda and the living room for visitors, but round a back, no stay so good. No, we want to restore civic pride. We want to restore a sense of identity, even for us Jamaicans. Senator Charles and Senator Skeffrey, you would remember that trip when we visited the Parliament in London, and I'll never forget your words, Senator Charles, one evening when we were returning, right, to our home there. You stopped amid a throng of tourists who were there looking at Big Ben, London Eye, and the other attraction. I will not forget your words, Senator Charles. You said, when I look at what hundreds of people are coming to see, and when I think about my own country, Jamaica, we are joking. We can do much better. This is our way out of debt. And so I commend the work that is being done by Minister of Tourism, the Honourable Edmund Bartlett. Can you imagine how prosperous we will be when we improve our product? We need to become fully immersed into the culture and to stop taking our heritage lightly. There are too many Jamaicans who treat with indifference emancipation and independence activities, and it is worrying. We should start feeling that agitation for our celebration in August. Let's look at the international world, Mr. President. Think of July the 4th in the US, the 14th of July in France, the 1st of July in Canada, the 5th of May in Mexico. Massive celebration of their history. So what's wrong with us? No university graduate with a degree in history in Jamaica should struggle to find employment when brand Jamaica is fully developed and marketed. And we must remember that the way in which we treat with our culture, our history, our heritage, it sends a message to the world about who we are and what we value. Mr. President, if we are to apply the principle of sustainable development to culture, then we must teach our children their history. We must teach the youths right. Every child should be able to, even in a simple way, tell the story of their island home, Jamaica. Mr. President, our children should have knowledge of Ska, Mento, the founding fathers of the reggae movement, dub poetry and the iconic poets, artists, playwrights, actors. Thank you, Senator. When a child says, Mr. President, when a child says that I am a Jamaican, it must be significant because that child would have been beaming with pride about his or her illustrious history. Ask a number of our young people the name of our heroes. A historical side, 2 songs done by Bob Marley, the National Pledge, 2 heritage songs, and they struggle. Ask them about Beyonce, Jay-Z, Rihanna, and the Kardashians. And this is not to say that anything is wrong with following the work of the superstars, but what about the story of our independence? What have we been teaching our children? Have we taught them Marley? Have we taught them Burning Spear, Muta Baruka, Jimmy Cliff, Third World? Have we taught them Marcia Griffiths? Have we taught them the lyrics of consciousness, lyrics that will make them into strong men and women of integrity and valor? Barrington Levy gave the instruction, no put it there, nah put them nowhere. Sex and guns, just keep them to the ground. Teach the youths them how to live. Teach the youths them how to survive. Not teach me nothing, just teach me something. Have we taught them? No woman, no cry. Have we taught them young, gifted, and black? Have we taught them this poem by Muta Baruka? Have we taught them to remember Marcus Garvey as per Burning Spear? And MP Juliet Holness's favorite song by Culture, Jaja see them a come. You know that one? But I a conqueror. Have we taught them that? Have we taught them the power of Bob Marley's One Love, song of the millennium? Have we taught them the power of Bob Marley's One Love, song of the millennium, from album of the millennium? Have we taught them, Mr. President? Have we taught our children that until the philosophy that holds one race superior and another inferior is finally and permanently rejected and abandoned? So we glorify violence in music and wonder why the youths are so cold? We glorify promiscuity and wonder why our daughters have lost themselves. The irony is that, Mr. President, and I have heard Elise Kelly, noted radio sensation and cultural enthusiast, say this quite often. Let me repeat the ironies that, Mr. President, and I've heard this repeated by Elise Kelly, noted radio sensation and cultural enthusiasts say, the emissaries of conscious positive lyrics, though overlooked in our society, and who can hardly get a forward here, enjoy international fame. When they tour Africa, Japan, Europe, they score bigly and are loved. Why can't they get that here at home? Because we have a generation that longs for things foreign. Because we have slacked off on instilling values of civic pride and to love what is ours. And the answer lies in our youths. Let us go back into our classrooms and engage our children. I would like the future to see schools with fully equipped music room and where the next big talent can be easily identified. Mr. President, my dream is for every child to know Jamaica. Between primary and high school, they should have been made to go to educational trips to every historical site. Remember those days, Mr. President, when our schools went on outing and you could barely sleep the night before to how you're so excited. Not every child has parents who can afford to take them privately. And wouldn't it be nice to see a partnership with parents, teachers, and students touring Jamaica? Bus companies would benefit, food and craft vendors would benefit, the sites would be kept vibrant, employment would benefit, society would benefit, brand Jamaica would benefit. Mr. President, I must ask you, did you watch the Magnum Kings and Queens of Dancehall competition this year? Did you watch it, Mr. President? I watched it. Senators, there was some controversy. There was some controversy regarding who should have won, the Jamaican suspense or the Japanese ranking pumpkin. Many Jamaicans were afraid to entertain the thought of a Japanese winning the coveted dancehall title. Despite being out of many one people, they thought that someone who is not of Jamaican heritage being crowned the Magnum Queen was troubling for many. I say to those persons, and to our dancehall superstars, wake up, wake up. The result of the Magnum competition should serve as a wake-up call because, newsflash, dancehall music is not copyrighted to Jamaica. Other countries are now in on the money, beating some of our sound system operators in world clash and taking the music more seriously than we are doing. Mr. President, that's in your opinion. Mr. President, when it comes to talent, style, originality, the Jamaican dancehall entertainer is superior. Lyrics for days, rhythm and soundtrack, as we would say, lock. To this day, the one-drop rhythm remains a staple in dancehall. To date, crowds go wild when they hear the anger management intro. To date, Pepper Seed and the recent Mildew rhythm have the crowd. Yes, man, me know the rhythm them, man. 1, 2, now. Huh? If you don't want me to read it over enough, you say, wheel and come again. Pull up that. The talent, Mr. President, the talent that we have as Jamaicans is undisputed. However, we are failing to handle this music form as professionals and in a way that shows that dancehall music is valuable to society. Dancehall music ought to represent fun, entertainment, and the voice of the people. Yes, we know that this form of music has the reputation of being hardcore, but even some well-known entertainers are concerned. Well-known entertainers are saying some things we are going to dancehall now need to stop. And some little youth when don't know about the history of the struggle to put dancehall music on the map and mash up the industry. Some outrageous and sexually explicit conduct in the dancehall is causing even some big dancehall fans to stop going because according to them, the thing get out of hand. On social media, the question is often asked, are this them a call dance? What about this is dancing? And this makes the music, Mr. President, very hard to defend. We need to get our act together while we are playing games with this powerful instrument called dancehall music. Other countries are weighing in on the money and are ready to own it. What makes things even more intense is the feuding and hate music between entertainers. There is enough space in the industry for everyone. We need to respect each other's talent. We need to respect each other's craft. And we need to have that desire to see another brother or sister in the dancehall fraternity do well. I urge the practitioners to bring back unity and decency in the dancehall. We are living in the digital world. It's just a click away from an incident going viral. What is it that we want the world to see about our Jamaican authentic dancehall? When I see Mr. President, Miss Kitty identifying with, embracing, and endorsing dancehall music, this music form, Miss Kitty, a vibrant and brilliant individual, I know that there is value in the music that must be identified, that must be supported, and that the industry will benefit from it when it is marketed properly by the chief operators. Mr. President, dancehall music can be the voice that can speak to our youths if we handle it well. We must realize that the locals depend on the music. What we want to push off and say, okay, we don't want to hear it. The locals depend on the music. The soup man, the jerk man, the roots man, the peanut vendor, the taxi operator, the promoter, the sound system owner, the disc jockey, the hairdresser, the barber, the nail technician, the store owner, the local tailor dressmaker who then go build them suit, the proprietor for the venue, security company. Many people depend on dancehall music, so we have to protect it. One entertainer said, dancehall can't stall, but we have to take the necessary steps to ensure that it doesn't. There's a matter of entertainment zoning and concern about the 2 a.m. lockoff that is argued to be affecting the industry. Minister Grange assures us that the ministry is seeking to strike the right balance between hosting entertainment events while respecting the rights of our neighbors. It is proposed it is proposed as part of the solution, amendment to the Noise Abatement Act to allow for entertainment zones will follow. The ministry is in discussion with NEPA concerning the constitution of zones. In addition, the Entertainment Industry Encouragement Act is intended to be the policy framework for entertainment incentives, and work is being done to expedite the passage of this legislation to provide the framework for an incentive regime for entertainment and the creative industries generally. Mr. President, our athletes continue to amaze the world. Last week in Senate, a number of us paid tribute to the legend, Dr. the Honourable Usain Bolt, who ran his final race on local soil. As we apply the principle of sustainable development to sports, we acknowledge the implementation of the high school sport improvement infrastructure project where, between 2015 and 2016, there were 9 out of 10 projects. 9 out of 10 projects were completed at a full cost of $78.4 million. And between 2016 to the present, 5 schools have benefited at a cost of $10 million each. We want to ensure that support is given that will unearth and strengthen the potential of the next generation of athletes, and to also provide the requisite support for those who continue to make us proud. Mr. President, crime and violence continues to undermine the potential of our nation. We are aware that this is a serious issue, and the recent surge of murders is of paramount concern. Prime Minister Andrew Holness emphasizes that we cannot continue to accept violence as the status quo, and also that we cannot project in the minds of our youth. I am getting there, and I'm also going to get to what you said. We cannot project into the minds of our youths that violence is okay. Successive governments have struggled to behead this monster, only to have it quieted for a more vicious return. Today, the challenge is with this administration to lead in dealing with the crime problem. The ministry reports that major crimes are down, but murder is unrelenting. Serious times will call for drastic measures, which I am sure that our colleague senator will outline. There is, Mr. President, could you ask Senator Morris to contain his excitement? Just to contain his excitement? Morris to Morris. The ministry, there is a popular view that most of these murders are gang-related, and in this view, I can reasonably opine that this problem did not begin overnight. Speculations are rife about fallout among lottery scammers, with families paying the ultimate price, meat for guns trade with families paying the ultimate price, and basically the sharing of the spoils of crime gone wrong, with families paying the ultimate price, and sometimes innocent family members can't catch Kwaku and them catching the shot. While we work to stop the murders, it is also a call for introspection. We tend to be reactive rather than proactive. We must start fighting crime aggressively in its embryonic stage. Stamp it out early before it snowballs into something that is difficult to control. Mr. President, we must smoke out criminals. Be on the alert. Mr. President, I need to be able to hear myself. The Senate needs to hear me, and Jamaica needs to hear me. Mr. President, as I was saying, we must smoke out criminals. Be on the alert, not provide a resting place for them in our homes. Mr. President, for example, let's say you live in country. You have this cousin that you have not seen for years. All of a sudden, this cousin decide that they're going to come and spend time. And somehow you can't get the full details of it. What is he or she running or hiding from? Sometimes they are taking trouble in your home. Parents, be firm with your children. Who are those boys or men who are calling your son out of the home? All of a sudden, your son lick head with bad company. Talk to your daughters. Nobody has the right to hurt another human being, but sometimes we cannot stop the heart and the intention of an evil person. So today, she dressed up and gone with Harry. Tomorrow with Sam. She's supposed to be dating John, but she's also close to Matthew. In the worst case scenario, Matthew, she would want to go out with you. Right? Huh? I will not say she go out with Lammy and go missing after that. I will not say that. Right? Mr. President, in the worst case scenario, sometimes we don't even know where to start looking. Parents, caregivers, don't be afraid. Put down your foot in your yard. Set rules. Talk to your children. Because sometimes when the hotter clubs come, the person who is deeply involved escapes, and innocent people who have no reason to be on the alert are compromised. We know that our justice system faces challenges pertaining adequate resources. However, we need to work vigorously to restore confidence in the justice system. Many Jamaicans are of the view that the process of getting justice is unwieldy, venal, and serpentine. Citizens need to feel confident that justice is swift and sure. Lately, there has been calls, Mr. President, for hanging. Lately, Mr. President, there has been calls for hanging to be resumed, and we can understand why people are angry. But I have this question. If we are not getting full cooperation from the community to hand over criminals, if we do not have the adequate resources to apprehend, then who are you going to catch for hang? Who are you going to catch to hang? So it is one more talk to distract and to seek attention. This government is interested in a holistic and effective fight against crime, not insightful and sensational, poorly thought out utterings to get attention. Mr. President, we must take collective. Mr. President, we must take collective responsibility for this monster that was fed, nursed, and tamed for decades. It has now turned on us, and nobody can score a point in what is happening in our country. Jamaica, Mr. President, Jamaica is saying to this government, you are in charge. We gave you our vote of confidence. Handle this. And Jamaica is also a happier ass or else. And Jamaica is also saying to the opposition, Jamaica is also saying, Charles, Jamaica is also saying to the opposition, you were at the helm for 23 of the last 28 years in government. How did you curtail crime, and how did we get to this point? Mr. President, I therefore, Mr. President, I am striking the balance. What we are... You see? Mr. President, I am striking the balance. I am striking the balance. We need to work together, government and opposition, to tackle this problem. Mr. President, I only have about 5 minutes.
Yes, acting leader.
Sign of things to come.
Very well put, Senator Morris. May the standing orders be suspended to allow the Speaker to complete her presentation. Aye? Against? Continue,
Thank you,
please,
Mr.
Senator
President.
Morris.
Thank you, colleagues. Mr. President, Jamaicans believe that we are quick to lock up the man who steals the mangoes, but the man who cannot account for millions of dollars of hard-earned taxpayers' money walks free and is only accused of mismanagement, misappropriation, cost overrun, youthful exuberance. Jamaicans will feel confident in the justice system when penalty is sure, regardless of money, power, and connections. When they see the handcuff going on some power brokers in society, even politicians and their friends, that is when they will be convinced that the thing gets serious. When we look at the international world, high-profile businessmen, professional sportsmen and women, hip-hop and R&B moguls, politicians who have to resign, pay hefty fines or serve time when they commit the crime, we wonder if it can happen here. It will. We are aware that every society faces problems with criminals, but we are all aware that every society faces problems with criminals, but the systems that are in place to apprehend and to maintain law and order is what will make the difference. We cannot continue, Mr. President, we cannot continue to move to secluded communities and barricade ourselves behind grills, shuttered and gated services. Mr. President, we encourage more Jamaicans to get involved in their communities. Join a service society. Become an active part, an active member of their Citizens Association, Neighborhood Watch, Sports Club. Support the young people. Go to their football matches and other events. Help them. Interact with them. In that way, we would have been in a position to influence them. I urge Jamaicans, get to know your neighbors. No, it's not the time for you to boast that I've never said hello to my neighbor. Look out for the children. Help them to make their way safely on the road. If you suspect that a child is being abused, report it. Teachers, if a child is absent from school and the trend is worrying, have the matter investigated. It is not okay for our children to just fall off the grid. Mr. President, a part of the crime-fighting initiative must include accounting for our citizens, something we will have to work on. We need to have structured communities. We can't have 200 homes in an area and there is only one address, Mango Walk. We also encourage more of our churches to have social intervention initiatives and to get on board in changing people's lives in a meaningful way. We need to restore the culture of sharing, caring, and empathizing, not taking out our cell phones to be the first to post someone's demise on social media. Mr. President, we are the same Jamaicans who go abroad and conform. We are punctual. We pay our bills. We pay our taxes. We drive carefully. We obey the rules of the road. We observe covenant restrictions. And we generally obey the law. Why are we accepting less for ourselves and our beloved country? Mr. President, Prime Minister Holness has been doing a superb job, and I commend him. With programs such as HOPE, which enables our youths to learn, earn, give back, and save. Our youths are confident that he has the will to constantly create opportunities for them. Mr. Prime Minister, we know that the problem of crime is a test of your mettle and resolve, but a test that you shall prevail upon. Mr. President, I have heard the tape. Mr. President, I have heard the tape of his campaign promise being replayed several times this week. I am confident that he's committed to delivering on that promise. In fact, Mr. President, this is something that as Jamaicans, we should all desire. So the Prime Minister's vision for Jamaica, Mr. President, is within the realm of objectives as a responsible and caring leader. Mr. President, if every citizen plays his and her part in fighting crime, together with action from the government, we will be able to sleep with our doors open. We will be able to walk in our communities without fear. We will be able to go to the bar and play dominoes without fear of drive-by. We are not going to relent on that, because this has to be a desire that any responsible government has to have for leading a country. Mr. President, we cannot fold our hands and challenge the Prime Minister when some of us have the criminal in our very homes. It is hypocritical. Mr. President, we need to pray for the leadership of this country. And Mr. President, despite this, as I close, despite all our plans.
Mr. President, just on a point of order. Is the member senator say that they are all criminals? She said some of us.
That is not a point of order. Would you allow her
But
to
sir, it must be a contravention of the criminal laws.
Come on, please.
No, Mr. President. That comment about throwing stone couldn't be intended for me. I'm law-abiding.
No, it was never intended for you. Go ahead,
and
please.
That's rude.
Senator Morris, go ahead.
Mr. President?
Senator Brown. Senator Morris, have a seat, please. Senator Brown.
Yeah. I rise on a point of order for your ruling. It is not for Senator Charles to shout at me to sit down, because that makes him rude, and it's out of order. And if you tolerate it, then clearly what you'll be... If you are tolerated, Mr. President. Mr. President, I think I'm on the floor. Mr. President, I'm on the floor.
You need to address me and stop addressing the...
that's you, I'm addressing. I'm saying I'm on the floor, but I'm hearing him being allowed to disrupt. So, Mr. President, I beg of you,
yeah, I have a point of order you want to make.
To keep the decorum of the Senate going.
Senator Morrison, please.
Mr. President, I'm so happy that the presentation has evoked this kind of agitation. Mr. President, despite all our plans, policies, and ideas, we must ask God to take the lead. Give us vision, lest we perish. Mr. President, he promised that if my people who are called by my name shall humble themselves and seek my face, I will hear from heaven and heal the land. We depend on God. Mr. President, colleagues, senators, I stand with our Prime Minister, the most Honourable Andrew Michael Holness. Thank you, Mr. President.
Well, Mr. President, with that very fulsome and exuberant, exciting, fulsome Constructive, informative, aspirational, futuristic, and prosperous in its orientation, notwithstanding certain pushbacks on the other side. Mr. President, it's not our intention to do any further business in the Senate today. Therefore, I would like to move a motion for the adjournment of the Senate for a date to be fixed.
We're going to have that motion, but also you're indicating that the State of the Nation debate will be continued at a future time. So the question is that the Senate be adjourned for a date to be fixed. Those in favor? Against? Senate stands adjourned.